All right, according to my ever accurate Apple Watch, it is 9 o'clock. Welcome to the KSB second webinar of our 2018-19 school year series. This is, I think, all three of ours probably favorite topic to talk about this time of year. And we're going to talk about personnel, teacher evaluation, remediation, and allowing teachers to become available to other opportunities. So this is our game plan. We're going to run this one through a series of hypotheticals because if you know us, you know we love our stories. So before we get going too hard and fast, if you see just a bunch of Hollywood squares on your screen, you can go up in the corner and pin the video of either our lovely faces or the video of the slides, but that way you don't have to watch the Hollywood squares. So what you should see on the slide now says the plan, so we'll give you a second to organize your computer screen how you want it. I also want to let you know that we are recording this, and we will put the recording up on the website behind a password protected login so that you'll be able to go back to it. What we'll do with this one is the same thing we did with the copyright webinar. We'll have one long video, but we'll also break this up into chunks. That's why I advanced it to this slide. So each one of these bullet points on this slide will be a separate little section of the video recording that we put up on the website. So you'll be able to go back and just watch the little chunks. If you have downloaded and printed the slides in advance, good for you, Gunner. But we have fiddled with the slides a little bit because we've added really important stuff like Bitmojis. And so an updated version of the slides will also be posted. Last little housekeeping piece. We love you and we want to hear from you, but we want you to mute your gosh darn computer. So if you are not muted now, I think we had everybody muted as they came on, but if you are not muted now, would you please make sure you're muted? It really hurts my feelings when you talk about, that my hair is bad and you think you're muted and you're not. And what happens more often is people are like, moving papers or whatever, and we can all hear it. We do want to give you all a chance to give us feedback. And so kind of the best way we've discovered to do that in these webinars is via text messaging. So this is my cell phone number, Bobby's cell phone number, damn South Dakotan, and Steve's cell phone number. As we go along, shoot us your questions via text. After each little chunk of these different scenarios that we're going to run, we'll take a break and solicit questions. But if you've got questions, you can just shoot them to us as they come up. You're not going to bother us a bit, and we'll get them answered. Sometime in here, I'll have to pee, and so we'll take a break. But we're hoping to be efficient and to finish this thing up for sure by noon, but in a perfect world, we might be able to finish up a little bit before noon. Any other housekeeping I missed?
I don't think so.
Okay, so here is our game plan. We're going to talk about the key terms, and then we're going to talk about our favorite archetypical teachers. So we're going to talk about the millennial. There was a kid this year who resigned his teaching job before the first day of school, and he brought his dad in to the superintendent's office to resign. That's the most millennial teacher I've ever seen. So we'll do that one. We'll do the bad in the clubhouse, the Barry Bonds teacher. We have a superintendent that calls and says sometimes, I'm from Crete, so I'll insert Crete's mascot. The superintendent calls and says, you know what, Karen, he's not bad, he's just not good enough to be a Cardinal. And so we're going to talk about that stereotypical teacher. We're going to talk about the teacher that loses his mind and smacks somebody. And then we're going to do the I don't give a fig long-term veteran teacher. So these are all some of our favorite archetypes.
So the idea is as we go through each of these, rather than just go through, all right, here's the non-renewal process, here's the termination process, here's the cancellation process, we're going to talk about them in the context of these individuals. So with the millennial, we're going to cover, for example, the Rule 10 requirements. When you evaluate somebody, what has to be in there, and the things the NSEA looks at to decide if they're not in there. But obviously that will be a component of the other evaluations of everybody else. So the idea is that it will build on each other, and hopefully you'll laugh a little bit at our hypotheticals.
Completely hypothetical.
Okay, so I'm going to start with the key terms here, and this is just going to be a quick recitation, mostly so that you know the terminology we're using. I don't care if you're a longtime superintendent or principal, we still get calls all the time confusing these terms. And so, yeah, we're just gonna not renew that 30-year veteran teacher. Well, that's not how it works, right? And so we want you to look smart when you're having your conference with that person, telling them that we're considering the termination of your contract, that'd be the appropriate phrase. If you have a union rep sitting in there saying, we're going to non-renew your contract, all you're doing is signaling to them that their cross-examination of you should include the tenure statutes and your evaluation policy, because you probably haven't read them recently. So the first thing we're going to talk about is kind of the concepts between probationary and tenured. Probationary is a teacher that has been employed for less than 3 full-time equivalent years, and only years where that teacher is at least a 0.5 FTE or greater counts. And so we get the how do you count to the tenure line question quite often, and you're using basically the FTE with a few mixed rules in there. So if you call us and say, hey, we have a 4th-year teacher, we're going to make sure that teacher's been full-time. Otherwise, it could be that they're actually still a probationary teacher. So if you're not probationary, you're tenured. This is somebody who's had passed the tenure line, the 3-year mark. And then the concept of a continuing contract. This applies to every certificate holder that works for a school. And this is a contract that automatically renews on April 15th unless the board gives a notice that complies with statute, board policy, or for superintendents, if you're on there, what's in your contract with respect to renewal and continuation. An oral reprimand. So as we move now into sort of the things that you can do short of a termination or non-renewal, there is a statute that has all this stuff in there. And we'll have a lot of this stuff in the slides later. But an oral reprimand, when you walk into a teacher's room and say, thou shalt not do that anymore, that is actually in the statute. We have a statute that talks about the things that a superintendent or his or her designee can do with respect to a certificate holder. One of those is an oral reprimand, and it does constitute a disciplinary action in the statutes. The next is a written reprimand. Karen's going to talk about those in her section in more detail. But this is considered a statutory disciplinary action. So we get the question all the time, well, yeah, don't worry, I just put it in your file and called it a reprimand. Well, that actually doesn't meet, if you haven't done the things required beforehand, meet with the employee and tell them what they've done wrong, provide them an opportunity to present their facts, and give them notice of their opportunity to either use the grievance procedure or to appeal it through the administrative chain of command if they don't have a grievance procedure that applies. So if you haven't done this stuff and you have reprimand written on the top of your document, they're going to tear you apart at a hearing and say, well, don't you understand what the statute says if you haven't done this stuff? So you can't just get the call about the teacher who, got caught drinking over the weekend with kids, put a written thing in the file and stick it in there and call it a reprimand. You'd actually have to do all these steps beforehand for it to meet the statute. An improvement plan, AKA a remediation plan. This is one of the slides, if you haven't printed off in front of you, that we changed. Steve and I were talking about how to best explain this. There is no statutory requirement that authorizes you to use a separate document to help a teacher improve. Everything that you're required to do by law and by NDE rule to help a teacher improve should be done in your evaluation instrument as well. So you have to give a teacher a chance to improve and remediate. That's in the statutes that Steve will talk about. You do not have to have a separate document apart from your evaluations called an improvement plan to be doing that. And so we like improvement plans or remediation plans to the extent you're doing more heavy lifting than would be appropriate for your evaluation instrument, but neither of those can replace each other, if that makes sense. This should be, again, considered an extension of your evaluations, and you should think about writing an improvement plan or remediation plan in light of complying with the Rule 10 requirements, right, which we'll talk about here in a bit. But don't just put in there what you think is appropriate for that teacher. That's important, but you should also make sure it complies with Rule 10. Suspension without pay. This, again, is one of those disciplinary actions in the statute, and it requires formal due process to remove somebody from their position and give them essentially leave without pay, unpaid leave. Administrative leave, on the other hand, so the reason we call administrative leave, we don't call it paid administrative leave, we call it administrative leave, is the statute actually authorizes it in certain circumstances in particular. For example, if you've given somebody a notice of cancellation of their contract, you can leave them on administrative leave pending a decision that has to be paid. The difference between that and sending a teacher home and saying you're taking leave without pay is that you have to give them a full-blown hearing to do that. So we get schools that call all the time, I sent her home without pay. Well, did you give her a hearing? Because you owe her one or him one if you're going to suspend him without pay. And we think and the NSC doesn't really fight us on this, that any certificate holder that you send home without pay or with pay on administrative leave, even if they're not pending a cancellation. So if you want to use it as a disciplinary measure, you're going to take a 3-day administrative leave to think about what you've done, right? We think that can be done because you're not depriving them of any of their pay and benefits. So there's no adverse employment action. So using these terms the right way, though, knowing when it has to be with pay versus without, is an important part of setting up your personnel case and not botching the statutes. Real quickly, I think hopefully everybody's familiar with these. If you're not, a non-renewal only applies to a probationary certificated employee. You don't have to non-renew a custodian, and you can't non-renew a fifth-year veteran teacher. There are certain people that it applies to. Don't use it willy-nilly to talk about any time you're not going to continue their contract. Termination, on the other hand, can never be used with a probationary employee. It is only for the discharge of a tenured employee at the end of the current contract year. Same concept as non-renewal. If you give them a notice of non-renewal in September and the board takes action on it, they have a contract for the rest of the year. The same thing with termination. It just depends whether they're probationary. Cancellation applies to any certificate holder, superintendent all the way on down to a first-year teacher. And we'll talk a little bit in the hypos about how this is actually carried out, but it must be done by a majority of the members of the school board, meaning if you have a 6-member board, you need 4 members to vote to cancel a contract.
So I just want to hop in here on this slide. I can't remember who it was, but there was a football game that was broadcast on TV, and some announcer referred to an offensive Nebraska player as a black shirt. And like Twitter blew up because he seemed like such a moron. Now, it's not the end of the world to call an offensive player a black shirt. It just illustrates your ignorance about the culture of the Nebraska football program, right? So the same thing goes for these terms. It's not, I mean, you don't lose the case if you call them by the wrong thing, but the union kind of knows that you're not steeped in teacher termination, cancellation, and non-renewal culture. So if nothing else, learning to use these terms in the right way signals that you know what you're about.
Yeah. And as part of our personnel process, if we get a call about a personnel case, at least I think we all are now, because of some recent NSEA tactics, are going to make you read your evaluation policy, Rule 10, and the Tenure Act, so that you have a full understanding, because they will cross-examine you on those things.
Yeah.
If you're saying the teacher should know and understand all of your board policies, for example, I think it's fair for them to say that as an administrator, you should know and understand the statutes, Rule 10, and your board policy on evaluation. The last thing here is an amendment to contract. We see it on occasion. Frankly, we probably don't get the question enough. Oh yeah, I just told her that if she wants to continue here, she's got to go pick up a SPED endorsement. That is an amendment of contract concept that you're putting in place, but probably not following the statutory requirements. So all this stuff about getting a hearing would also apply to an amendment of any certificate holder's contract. So we're not going to dig into that a ton, but it does come with the same sort of due process requirements as terminating your contract. Okay.
All right, our first typo is a millennial. This will be Anna. The fact that Karen's daughter's name is Anna and she's 22 is completely coincidental. That emoji looks nothing like her.
And that we gave it to the most crotchety KSB lawyer to deal with a millennial. So.
All right, so we've got Anna. She's a first-year teacher who wasn't thrilled about basically moving to Wyoming here in Nebraska to teach in your district. She got good grades and was charming during the interview. She had a pretty solid first 2 months, but really started to struggle in November. Anna is struggling to control her 4th grade class, and her lesson planning and weekly grades of entry have slipped. You've been in the room regularly, and she gets really frustrated by you being there and by the kids. Things are getting worse, and you are getting complaints from other teachers that it's spilling over to their rooms. You're worried that more experienced teachers with kids in her room are getting upset. You have given Anna several ideas orally, and you've sent her some written materials on classroom control. You've thought about sending her to a training on classroom management, but haven't done so yet. Your superintendent and the board members are hearing grumblings, and a parent with a kid in class stops you in the parking lot after the last football game. Just got to Anna's name on the evaluation list, and you keep to be sure that you complete all evaluations. Superintendent checks in with you and says, hey, you're in control of this, you're on top of it, right? Now what do we do? All right, we've got several evaluation requirements under state law, Rule 10, and under your board policy. Sometimes they're the same, sometimes they're not, and so you have to look in all 3 places. Rule 10, as you'll see, adds a few adjectives and adverbs sometimes that I think we're trying to steal second base, if not home plate, and so we'll take a look at those. We put the statute in here just so, hey, take a look at it. But we'll summarize this in a minute. But part of what I want you to take away from this is there's nothing in this statute that says you have to give anything in writing. But I would strongly encourage you, you'd be crazy not to do all of this in writing. It says down in the third paragraph, you give a list of deficiencies, a list of suggestions for improvement. There was an old Nebraska Supreme Court case where the argument was, well, they didn't give it to me in writing, and a court found that the oral suggestions that were given were sufficient. I'm not so sure that would fly today because it was before they amended Rule 10, and it's an issue that hasn't been litigated yet, and I'd rather keep you guys out of it. I think we win it, but I'd rather keep you guys out of it if we could. So take a look at that when you get a chance. Rule 10, you have to have a written board policy for the evaluation of certificated employees. It has to be approved by the commissioner. That is an ongoing issue that we have, and it's one of the NSEA tactics that they use. We need to make sure that the evaluation instrument that you have on file with the department matches the one you're actually using.
Can I just jump in there?
Sure.
We have started just as a matter of course, ordering that from the Department of Ed. If you have not personally put eyes on what your board has on file, you should call the department and ask. It is shocking to me, probably what, 30% of the time, 20% of the time?
Yeah.
The instrument that the school has used to evaluate the teacher is not the one that's on file. And the NSEA has figured this out, so they've started asking. The farthest I've ever gotten using the wrong instrument, we were taking depositions, and I ended up discovering that that we hadn't used the right form. But we don't take depositions in every case. And you do not want to be in a board meeting at midnight and have the NSEA whip out a different instrument that you didn't use. So that's one piece of homework for everybody to have, to double check and make sure you're using the instrument. Even if the one on file is crap, use it and then change it.
And I would check both your certificate, your teacher evaluations, and your superintendent evaluations.
Yes.
What we find is compliance goes like this. It goes up and down, up and down. It's because we present or the other firms present and they tell you, hey, check this. Everybody does. A new superintendent moves in and says, I don't like this instrument. They start using a different one. Don't bother filing it. And so don't assume that whatever you're using is the one that's on file with NDE. These are the other Rule 10 requirements. You have to have written procedures, and you have to have specific district-defined evaluation criteria. Up in that right-hand corner, this is where they kind of steal second base a little bit. I'll talk about it in the other slide as well, but you have to specify all noted deficiencies. That's not in the statute. It doesn't say all. It says they'll give you a list. And so they put a little bit more of a burden on you there. The specific means for the correction of the noted deficiencies, again, specific means is not in the statute. It says a list of suggestions for improvement, and then an adequate timeline for implementing those concrete suggestions for improvement. I think I know what concrete means. I'm not positive.
It's definitely not cement.
But yeah, it's definitely not from the statute either. And so they've slipped that in there too. And you can see they're trying to put the burden on you to be more specific and to provide more rather than less. So just keep in mind that the rules are going to require more than what the statute does. Rule 10, again, there's make sure your policy and evaluation instruments are the right ones. We talked about that. An example that kind of follows along with Anna's hypo. We had the Cox case back in 1997. It's one of the first cases I was involved with as a new attorney. It had just come out when I had started. We had a first-year band teacher at Cool Junction. She had not been formally evaluated in the first semester. But come the end of the first semester, students, they put in a policy, the administration put the policy in that says every class has to have an end of the semester test. And so they had apparently never had one in band or it hadn't been much. She instituted one and the students revolted. They just couldn't believe that they were gonna have to take a test in band. And as a result of that, kids were dropping out, threatening to drop out, things like that. And so now the school and the administration get a little freaked out that people are trying to take off. So she has her formal evaluation in the first semester. They don't give it to her, or they did it on January 28th. That's when they actually observed her in the classroom. But really the guts of her evaluation document was based upon informal walkthroughs and other observations they had made during the first semester. And the only thing they told her is you need to improve your communication, especially with students. You need to use positive reinforcement when appropriate, and that went back to kids were revolting when they had to take this test. And so the January 28th was in the second semester. She didn't get that first semester evaluation. Supreme Court said it's undisputed that she did not receive a list of deficiencies, a list of suggestions for improvement, and assistance in overcoming the deficiencies, or any follow-up evaluations and assistance from deficiencies. Essentially what happened is kids and parents were told, administration reacts, and it was a little too late. They hadn't evaluated her. And you can see there in that this is from the Nebraska Supreme Court. They're not quoting Rule 10 there, they're quoting the statute. And it doesn't have that additional information in it. It has to be based on actual classroom observations for an entire instructional period. That first evaluation she received was based on bits and pieces of informal evaluation that they had made of her performance during the first semester. So the evaluation summary, you have to do an observation and evaluation once each semester. We think that, I mean, obviously the best practice is get that all done. Not only the in-classroom observation, but the written evaluation and the meeting with the teacher to review that evaluation. That should all be done within that first semester and in each semester. It has to be a full instructional period. Don't pop out and cover an emergency. If you do, you're gonna have to redo the full instructional period part. You need to have a list of deficiencies. Again, it says written. That's certainly the best practice. The statute doesn't say that, but NDE will tell you that that's what's expected. I can tell you to hearing that absolutely we expect it, and if you didn't do it in writing, you'll get grilled. Doesn't mean we won't present evidence on what was orally told to that teacher, especially when it's in between formal evaluations or in between an improvement plan. You need to have concrete suggestions for improvement, again, in writing. Sometimes this is where I think that when we look at the remediation plans, when we look at evaluations, this is kind of soft, it's kind of flowery. It's not as specific, and I think that concrete part might catch us sometimes. So we have to be careful about that. Sufficient time to improve. This can be problematic. That was problematic in the Cox case. They basically wanted a time machine to go back in time and make her improve. They didn't give her any time to improve. They just decided that kids have revolted and we're done with you. And I understand when you've got a bad teacher in the classroom. I mean, the research shows the faster you get them out, the better the kids are going to be. But we still have to give them sufficient time, and we have to make the effort to help them
So
improve.
Steve, if you're a mean lawyer and you, or a mean administrator and you want to make it look like sufficient time, is there any like verbiage you can put into the document to make it shorter? Because I say things like, any competent teacher would know that they need to have grades entered. I expect that improvement to happen immediately. So those are, I mean, if you're doing a hurry up timeline, that's my point. If you're doing a hurry up timeline, kind of own it. But then what I try to do is make it sound like, because my very first hearing that I ever did was a teacher that wrapped herself up in saran wrap and met her husband at the door and then told her kids in the classroom about it, which both my principal and my superintendent were kind of excited until they realized who it was that was wrapped up in saran wrap. And then anyway, so we got around the sufficient time to improve by saying, you should have known, this needs to stop immediately because you should know right now that that's not okay. So,
But to me, that's part of the thinking in making sure that every piece of paper that you give, you can point to something in your policy, in Rule 10 in the statute that you're accomplishing with that.
yes.
Because they will question why you didn't do that at a hearing. So to Karen's point, that's not mean to say that is probably actually true if y'all had to answer honestly. It's never been appropriate to talk about wrapping yourself in saran wrap and meeting your spouse at the door. So the fact that we expect that immediately, we can point to Rule 10 and say, look, this is we complied with it.
Yeah.
We're trying to get around it. The opposite is true.
Yeah.
But if you ask nicely in the evaluate or in our evaluation documents, perhaps we'll reenact that scene in the saran wrap. You can maybe vote on who that should be. Anyway, our Supreme Court, we've had cases from other states where, I'll give you a ridiculous example, a teacher commits murder. You don't have to put in the evaluation document, don't kill students. I mean, that's silly. And so other states have made very clear, there are some offenses that are so bad you don't have to give any remediation. And we don't have great guidance in our state as to what that means. So we kind of fine tune that as we go along, but just understand there are some things that are so bad that you don't have to remediate. You have to give that follow-up evaluation and assistance. I think as a principal, as an administrator, that's probably the most difficult and certainly most time-consuming part of this process. It's frustrating, especially, let's face it, there are times where you see a teacher that is so bad that you think, I don't want to spend any time on this teacher. You have to. And I get that can be frustrating, especially if they're not quite up to the cancellation line and you're going to go the non-renewal route. It can be difficult and frustrating. these are the statutes. We just put these in here so you'll have a chance to read them. We're going to summarize those here. The non-renewal process, you got to give, again, notice on or before April 15th. I would say check your contracts. There are still some old contracts floating around out there. And when I say, I'm talking mid-70s, that give an earlier deadline than April 15th. Number one, to give those contracts, update them, but two, just check and make sure you don't have a different date in your employment contract or in your negotiated agreement. They have 7 days to make a request for a hearing. If they, if they do that, we have 30 days to hold a hearing. But we have to give them notice of the basis for non-renewal, a list of the witnesses, and any exhibits we plan to use at the hearing 5 days before the hearing. The matter has to be confidential until the hearing or board action is scheduled. And that can be tough sometimes. Rumors start to float around in the smaller towns. But as long as they're not coming from us, the school, the administration, the school board, we're in good shape. There it is, that you have to conduct that hearing before the board within 30 days of the hearing request. That can be extended if both sides agree, but otherwise it's 30 days. Statutorily, it does say this will be an informal hearing, but in reality, that's not how it works. In the good old days, it really was informal. The teacher would come to the hearing maybe with a rep, maybe by themselves, and they would plead their case to the board. And that, I think, was what initially was intended. But the first time one of those got appealed, the court said, where's your record? Where's your recording of what happened? Where's the word-for-word document that tells me what occurred at your hearing? They said, well, there isn't one. And they said, oh, reversed. You've got to have a record. The burden to have that record is on the school district. And so that has really made it more formal. And each ruling that's come from the court really has made it more formal, to the point that if you went to a non-renewal hearing or a cancellation hearing for that matter, you wouldn't be able to tell the difference in all likelihood. They have a chance to discuss and explain their position on continuing employment. It's a little more than that now. It's examination and cross-examination and redirect and recross-examination. It goes on and on. The board decision may be for any reason except an unconstitutional one. And that's one where I think I'm anxious to test is for any reason or no reason at all. They just aren't good enough. They aren't good enough to be a Duke. They're not good enough to be a Cardinal, that kind of thing. A majority of the quorum for a probationary teacher is sufficient. So if 4 people show up, you could have a vote of 3 to 1, and that would carry the day. As you'll see, that's a little different for the more formal people. The employee may resign, a probationary employee may resign by statute at any time before final determination by the board. And I think Karen and I at least have had this experience where you do the whole hearing, they go in to deliberate, and the teacher and their representative get together and meet and decide we're getting fired. We knew this was coming. Now I really know it. And so they'll submit their resignation so they can say they quit instead of being fired.
And I had a board say, oh, hell no, you put us through this. We want to come fire you. And it was like, no, she's entitled to resign. And so then the board came out of closed session and the board president read a statement that said, they were so mad. We were going to fire her. We had to accept her resignation because the lawyer said we had to, but we really wanted to fire her.
All right, and the final decision must be made by May 15th. Again, that's by statute. It has to be a written decision. All right, so our options with Anna, what can we do? Obviously, the sooner you get legal counsel involved, the better. The earlier in the year, we can make sure that remediation process goes as smoothly as it can, and it'll be legally sufficient by the time we get to the end of the year, or we reach the point where cancellation is going to be necessary.
Well, there's a reason we're doing this presentation right now in November
Yes.
and not in February. And that's because you're most likely to avoid a hearing by starting to think about one now.
Here's how we process the case. Can she improve? Really, I look at first, did you help her? Did you actually help her remediate? What kind of things can we do to remediate that teacher? Is it more likely a cancellation case? How bad is it? In this case, there was talk of sending Anna to the class management course. And okay, we're going to talk about, are we actually going to do that? Is it even available during the middle of the year? Is it too late? If it is, what are we going to do? Are we going to observe her classroom, have her video? Are we going to have her read books? What are we going to do to make sure that we're doing our job and make sure that she can finish out the year? Will the board support you? This is an ongoing issue. We can have a legally airtight case. It doesn't matter if we've got political connections. or a board that simply is not going to pull the trigger. And it seems like every case has some weird political issue. They go to church together, they're on some council together, their mother teaches at the district and has for 30 years. Dad owns the bank, dad's the biggest landowner in town. All of those kinds of issues come up.
Well, and part of the reason we put it in there, this so candidly, is at the point you're calling us, probably you've made a decision that that teacher's very likely not going to make it. And so we start processing the case from that perspective, but don't be offended when we ask you, is there a chance to, we're not educational experts, but we're asking that because that's exactly what the NSEA might ask you. When did you decide she needed to be fired? Right? If you're not prepared and thinking through that from the beginning, they're going to catch you in that on the stand. So that's why we just are straight up about, can she improve? What have you done? Okay, well, no. Okay, can she finish out the year, or is it too bad? And so that's how we think of it here.
Well, go ahead.
No. I was just saying, this is where we look at the Cox case. You know, in Cox, in our case here, we gave her some oral suggestions. We gave her some written materials. We didn't give her an evaluation. We didn't give her formal suggestions for improvement. We haven't evaluated yet. So we need to make sure we jump through all those hoops to meet all the Cox issues, so that we evaluate her in the first semester and give her all the help she needs and repeat that in the second semester.
This is the point, and we're going to talk about this at various times today, but talking about what your board needs us to prove, this is the time to talk about it now, not right before the hearing. So Joe works at the co-op and manages a bunch of lazy, shiftless people, so he's going to want us to be real hard-nosed. Sally goes to church with this lady, so she's going to want us to show mercy. The hospital administrator is going to be really offended by breach of confidentiality. So understanding what your board members need us to show them in order for them to be comfortable supporting you, that there's nothing wrong in that. That's just being a really good administrator and knowing what your board expects.
Well, I mean, if you're going to a jury trial, you spend days picking the right ones, right? Figuring out what makes people tick. You need to think of your board as your jury at that point, and that's how we're thinking of it.
Yeah.
Because frankly, they are.
Yeah.
In terms of getting the votes. And you know, the notion that you would call a lawyer before you even do the first semester evaluation of a first year teacher, we wish that was less strange to think about to some of you, because we could, if you're already made this decision, when the superintendent sticks his or her head in and says, hey, we're going to address this, right? We're going to start asking you what that means. What is the end result here? And if you already know that, then they can help you make sure you tick the boxes for Cox and the rules.
Yeah. Sometimes people go to hearing because they're going to go to hearing, but we are much more likely to have a case go to hearing if you call us after all the paperwork is done than if you call us before. And it's not that you're not competent, like you've got the educational stuff squared away, but having us be able to throw some of this stuff in early makes all the difference in the world.
The other options, cancellation. I mean, is she that bad? Is she so bad you can't remediate her? That would be tough in this particular case. I think you're going to have to jump through hoops and help her remediate. So that would be a tough sell. The counsel out conversation. This always makes me nervous. Me too. We have some veteran and some not so veteran administrators who think, oh, I'll just talk to her, and you know, by the time I'm done talking, she's not going to want to work here. She'll leave. It's a good conversation to have. It's just not. I don't want that to be plan A. I want that to be plan B.
Yes.
I want you to be prepared to move forward with a non-renewal or a cancellation if it's necessary. I don't want that to be, it doesn't matter if we screwed up the paperwork. It doesn't matter if we followed Cox. It doesn't matter any of those things. We're just, she'll leave. I'm good. And my fear is you get away with it once and it really empowers you to, oh, this isn't that bad. All those things they said, it doesn't matter. So just be very careful. Yes, we're going to have that conversation, but that's plan B, not plan A. An improvement plan, are we going to do one? What are you going to put in the evaluation, as we'll talk about a little later. It doesn't have to be a separate document. It can be. It doesn't have to be. And the improvement, I guess maybe this is as good a place as any to talk about one of the NSEA tactics on these plans and evaluations. It is a hot button issue with the NSEA that attorneys review these documents for you, make changes to them, or outright write them. They do not like that. They are attacking that before the hearing. They're attacking it in meetings with you. They're attacking it at the hearings. And so in a perfect world, you guys would write great improvement plans and wouldn't need any input from us. You can honestly say, I wrote that. And so just be aware that the NSCA is coming after schools and administrators for having other people write their plans or even tweak their plans and evaluations. And evaluate no matter what, don't pull punches. And this, we see this a lot with what we call the cliff. They'll have great evaluations for 2.5 years, then you start swinging in that last half semester or last half of the year. You got to be direct. I mean, you don't have to be mean, but you do have to be direct. If you see deficiencies, you have to note those. You have to tell them, and you have to get those remediated.
I just want to jump in here. I always think of the verse in Ephesians. If you want to be kind to people, and you're like thinking, what would Jesus do? Ephesians chapter 4 says, speak the truth in love. Lying to people, telling them they're good when they're not, that is not loving. That is not a kindness. In fact, it feels like a betrayal to the teacher if you have not been honest with him or her about their deficiencies. So I just throw that in there. They hear me say it here all the time. You speak the truth in love.
And I was born in Detroit, and I say burn their house down.
Real quickly, for those of you that are having issues, I just checked. Let us know if those continue. It seems like it is kind of a mixed bag. So anyway, sorry.
All right, give that written list of deficiencies, concrete suggestions for improvement. Again, your evaluation could be the improvement plan. It does not have to be a separate document. And consider the timeline for issuing that notice of renewal. If you issue it early in the year, you've got a lame duck teacher for the rest of the year. That's not ideal. On the other hand, if you've already made up your mind, we really want to continue for several more months limping through. So giving, that's kind of an art at times as to when you're going to give that notice of non-renewal.
I just have to tell you, I love this. Well, see, I love this back channel because I have some of you texting me. Someone just thought maybe lightning would strike if I was quoting Bible verses. So that's those of you that are having tech issues, I've had a couple texts, and what I'm doing is texting. Then our tech guy is here, so he's reaching out to ESU1 right now.
Right, this is you.
Say type call actor. Okay, so this is the bad in the clubhouse, and so Anna did these Bitmojis for us, and we were vastly entertained because they're supposed to represent people that work with us or around us. So this is Cody. Cody is a student teacher at the district, and he seems good. He's also science endorsed, which makes all the difference in the world, right? So you hired him because he was decent as a student teacher, and he's science endorsed. He was pretty good in his first year. A few typical new teacher troubles, but he's getting slowly better. Problem is, this summer he married into the family that owns like half the county and has a lot of political clout in the community. And his wife also works in town at the bank, probably in the loan department where farmers get loans, and she knows everybody. They're building a new house, so they are putting down deep roots. And he's also gotten elected to the local church board, so he understood me when I quoted Ephesians, unlike you bad administrators out there. Problem is, Cody, now that he feels like he is secure, his attitude has completely changed. He loves to stir the pot. He's chitter-chattering in the teacher's lounge like a middle school girl. There's a fellow teacher that allegedly had an affair that he heard about from his in-laws, and now he makes little snippy comments about it all the time. He speculates all the time about it. Every little rift between the teachers, he's jumping in. And he's also fighting with the existing staff about what curriculum should be purchased as you're making this decision. At a recent science department meeting with the admin team, he said, you know what, if you don't agree with me, I'll just have Dave donate the money, and then we'll let him pick. And obviously he thinks his father-in-law is gonna pick the curriculum that Cody wants. Every Friday and Saturday night, he is just consistently stirring the pot. And now teachers, his peers, are getting concerned and frustrated, and they're starting to come complain to you. Quick footnote, I love this. Notice that they don't tell Cody to knock it off. They come to you and tell you to tell Cody to knock it off, which I think the whole social and emotional learning piece that we should put in the curriculum for students, we also should hold teachers accountable to, because they should start with Cody, but you know how that is. But bottom line is, it's pretty clear that Cody thinks now that he's married into the biggest money family in town, he's got the power to basically do what he wants. His in-laws are real supportive of the school because they were good parents when their kids were students. but now their only basis of information about what's happening at the school is Cody, and so they're not above calling in a favor. And now that Cody's their inside man, so to speak, it's gotten worse. So what do you do about Cody? I think the first thing we need to start talking about here is lesson plans. And I need to swap this slide so that people that are watching it there can see it. So it says, the kids are much better behaved since I crossed out lesson plans and wrote evil plot on my planner, which makes me laugh hysterically. Okay, so if we're gonna give a reprimand, Bobby mentioned this before, it's not just a matter of you write something up, you stick it in his file and you call it good. There is an actual statutory process. Reprimand is covered as something that you're empowered to do by the statute, but the unicameral, you know, what they giveth, they also taketh away. They give you the power to give a reprimand, but they also make you jump through certain hoops. So before you issue a reprimand, you have to confer with the teacher. Cody, you're doing this stuff, this is not so bueno. What do you have to say for yourself? You have to give the teacher a chance to speak up. Now, I've had administrators say, I don't want to do that because all Cody's gonna do is make excuses and tell me a bunch of lies. Look, I don't care what Cody says in response. You can believe him or not believe him, but giving him the chance to say the words that come out of his mouth, that is what is statutorily significant.
And why would you not add that to the reprimand?
Right.
When we met, you told me you weren't even at the bar on Saturday night, but I saw a Facebook post from you in the bar on Saturday night. Yeah. Meeting with them can oftentimes, if they have just a crap attitude about it, put that in the reprimand, right?
You were defensive and evasive when we met. Yeah.
Yeah, what we're trying to do here.
Absolutely. And I love putting stuff in there if they're shirty with you when you actually meet.
When we met to confer about this, signals your statutory compliance as well.
So this next bullet point, tell the teacher the reason for the proposed action. Sometimes administrators get hung up on that. No, Mrs. Johnson said she didn't want to get involved. So when she told me that Cody was talking crap in the teacher's lounge, and now I can't say that because he'll know that it's Mrs. Jones. Look, at some point in time, just fundamental fairness requires you to tell the teacher basically what's gotten you all fired up. So if Mrs. Jones is such a baby that she doesn't want her name involved, I would actually, step one, I think, is counseling Mrs. Jones about what's expected of a professional. But number two, if you really want to protect Mrs. Jones because her husband farms for this family or whatever, you don't have to tell Cody who. You can say, staff members have reported to me, blah, blah, blah. Or you can even say, I have been informed. I don't like that passive voice because it just makes you sound weak. But you do have to tell the teacher, whatever the reason that got you fired up is, you have to tell the teacher what it is. I saw you interact with the student in an inappropriate manner. I saw your Facebook post. I have had complaints, whatever it is. And then you give the teacher a version to present his or her version of the facts. Principals, this is exactly like Goss versus Lopez due process for kids before you impose a disciplinary consequence. You just do that same process with teacher. So they told me you were talking crap. What do you have to say for yourself? Let Cody talk. I don't care what he says. Make some good notes because whatever he says, we might be able to use against him. But let him give you his version of the facts. After that meeting, sometimes at that meeting, we'll have a draft reprimand ready to go, and you can give it to the teacher right then and there. I kind of like embroidering in anything that the teacher says. So if you want to add that in, you can just give the teacher the reprimand separately a little bit after the meeting. If Cody does not agree with what you've given him in the reprimand, he may grieve it under your negotiated agreement. If there is no grievance procedure in the negotiated agreement, the statute gives the teacher the ability to challenge this through the chain of command. Quick footnote, there is a UNISERV rep out there who's new-ish, although they're all new right now, who takes the position that the teacher can do both, and that if you don't tell them both, that you've somehow committed a violation of the statute. I don't agree with that. And so we continue to say either grieve it or contest it through the chain of command, but just be prepared that there's kind of a snotty UNISERV rep out there that will tell you you've done it wrong. Don't panic, just say, hey, we've talked to KSB and we don't care what you say.
So one quick thing to add, Karen mentioned, and it happens a lot, this may be on the slide. So if you bring the reprimand with you, then you've sort of signaled that you never intended to take whatever they said seriously. And that can be okay if they smacked a kid, right? Yeah. Okay, just wanted to confirm, thought so, here you go. But I've had in at least a couple of cases recently, a UNISERV rep, or whatever they call them now, an area rep, has been at the meeting with the teacher and did not let the school know, which I don't like. They always used to call and at least give you a heads up, and have said, well, how do you have the reprimand ready if you still had to meet with the teacher and ask what happened? So
And
especially,
the answer to that is, well, I thought I knew what had happened, and this meeting has not changed my mind, so this draft can now be formal.
exactly. So there's an answer for it, but just know
Yeah.
that they're thinking about that, those couple statutory steps, the flurry of activity before you can actually give them the document. So if it makes you feel better to have it, to organize your thoughts, you should totally put it together beforehand. But there's nothing wrong with having the meeting and saying, I'm going to think about it, and then sending it 5 minutes later either, if you're worried about it.
So when you call us and tell us, we talk it over and we decide that we're going to do a reprimand, we send you a memo that kind of explains this process, so you've got kind of step by step. And we also send you a draft reprimand. That doesn't mean you have to give it to them right then and there. You can wait and fiddle with it. One other thing is we're talking, and you're going to see this as a theme that develops. The NSCA is losing membership. Like, millennials don't want to pay to be a member of the union unless they get something. And I think that is why we're starting to see UNISERV reps or area directors or whatever the hell they're called, like, try to show that they're valuable. So I think you should expect more kind of picky little things like this because they're showing their value. And so just don't be thrown off your stride by that. I think you should kind of expect that. Okay, so this was the last bullet point, was the point. There's no mandatory format, but you should say in that grievance that they do have the right to appeal. And then we always say you are directed, if you disagree with anything I've said, you are directed to file that disagreement with me in writing within 7 days. That's not in the statute. The reason we say that is because if the teacher doesn't say anything, then 7 days later, we take the position that you've admitted everything that we wrote in this document. If they do file a response, absolutely, positively, never write this down. Never let the teacher have the last word. And so we, again, I think as part of the effort to show that they're valuable, we're seeing more UNISERV directors help their teacher write a response. And then we need to respond, we call it a reply to that response. But so that kind of goes back and forth. But so this all is stuff that we put into the grievance that isn't necessarily required or in a format, but that we include. Last thing, a few evaluation models now are including all kinds of forms. Like Talented, I think, has a form for a reprimand. Use whatever form you've put on file. If you've put a form on file, you've kind of limited yourself. But we can always, don't let the form drive it. We can always get around it. Anything else on that? If you are struggling with exactly how to articulate what's in a reprimand, I love this. I taught business and professional and interpersonal communications back in the day, and I love this FRISC model, which is a way to have a fierce conversation. So first, you say what the facts are, what did they do, and why is that a problem? Secondly, what's the rule? What rule did they break, and how should they have known about the rule? Secondly, why does it matter? This is the part that sometimes we miss. It's obvious to everybody that you shouldn't hit a kid, but saying striking a child is corporal punishment, that's a violation of the law. It also is damaging to your relationship with students and the community. That impact step makes your document way more powerful. And if you can connect it to kids, that always makes us stronger. The S is what specifically do you want them to do? You must never again put your hands on kid in anger. Cody, you must immediately cease from having conversations which have a negative cultural impact on the school district. Be real specific, because if the teacher is wanting to play games with you, they're going to say, I didn't know what I was supposed to do. And so specifying exactly what directive you want to give them is important, and then including the consequences if you don't.
Yeah, real quick, I just got the question last week. I can't put an improvement directive in a reprimand though, right? And the answer is absolutely you can, right? Again, there is no form, there's no requirement. What's required by the statutes in Rule 10 is in those, but it doesn't say that you can only use a reprimand to call out the bad behavior. Then you must have a separate improvement or remediation document to fix it. Just not true, right? The only way that that would change is if your board's policy requires you to do separate documents for separate steps.
So I've done reprimands, and this one I might. I've done reprimands where I direct them to read a book. Cody, you are required to read John Gordon's Energy Bus. Do it, because that you're being reprimanded for being an energy vampire. There's nothing that says you cannot do that. And then put in there what's going to happen if they don't. Now, quick footnote, we're kind of vague when we say what's going to happen. We say things like you will be subject to additional employment-related discipline up to and including the possible cancellation or termination of your employment, so that we don't want to lock ourselves in. If this happens again, I'm going to cancel you. We want to like have it be lots of bad things will happen, including this really bad thing, but it could be other stuff too. And then finally, knowledge, showing that the employee knows you're documenting. There's no statutory requirement that the employee agree. That signature line on the reprimand form that we give you is not that the employee is saying, yes, boss, thank you so much for giving this to me. It simply acknowledges that they have gotten a copy and they know it's going to be in the file. So I love this FRISC model. I like these kind of little mnemonics. For the record, it also works really well with kids and spouses as a model for having a difficult conversation.
Co-workers.
Anything else?
One quick thing, we put in our form reprimands and we send them to you. You must let me know if you have any questions, right? We make it very specific. So this knowledge component is, yes, they know that they got it, but we direct them. Don't come back 2 months later and say, I wasn't real clear on whether I had to read the energy bus or something else, right? We put any part of this that you disagree with, you have to respond, like Karen said. You have to let me know if you have any questions as soon as you have them.
Yeah, and we put a timeline on that so they don't play games. Absolutely. So this goes back to when you meet with Cody and he tells you, oh no, I don't even go to the bar. If you don't believe the teacher, that's fine. And one of the problems is when people violate social norms by just lying to you, that is like such a social norm violation. Sometimes people don't know what to do. So here's your marching orders. If you don't believe them, you can say, I'm sorry, I find your explanation not to be credible. I believe you are minimizing your misconduct, or I believe you've been dishonest with me. I wouldn't use the L word. I don't say you lied or you are a liar. I do say you attempted to be dishonest or you dissimulated, and I kind of use some other words to kind of dance around it, but say so. If you don't believe them, you should say so. And then say why. I do not believe you because I find the student reports to be credible. I do not believe you because I saw your Facebook post that you were at the bar. I do not believe you because of your long history of engaging in similar conduct, whatever it is. And again, this is some place where we can be really helpful because we've thought of a lot of ways to say you're a liar, liar, pants on fire. So if you're struggling with how to write it, reach out to your attorneys because they probably have written it somehow. And then the last thing is when you don't believe them and it's like a he said, she said kind of situation, this is my go-to, which is the even if. Even if it's true that you weren't at the bar, I still believe that overall you've been talking crap about the district. Even if you only grabbed the kid by the shoulders to stop him from falling down while you were screaming at him, you should be reminded that you never touch a kid. So those are the kind of ways to dance around that who's telling the truth question if you don't have a Perry Mason moment when the teacher just admits that they did everything that you said they did wrong. And then when you're unsure of the facts entirely, you don't know who to believe, I still do a written documentation that we are reprimanding the teacher if this happened, and if it didn't happen, we are reminding you that that all teachers are expected to not touch kids in anger, not get drunk at the bar and flash the bartender. We're trying to think of examples that haven't happened. So that's what you do. If you're not sure, you say, I'm reminding you that this is a professional expectation so that you've got an anchor dropped. If this behavior continues, you have a way to get at it. Anything else on that? Finally, this is this goes back to the idea that Cody's signature at the bottom of that does not mean it's collaborative. This is not an IEP meeting where the parents get to speak in, the employee doesn't get a chance to. We just recently had an employee and UNICEF rep that sat down and wanted to tell the principal, we don't like how you've written this, rephrase this. And so the principal sat down and let them edit his reprimand and then redid it and gave it to the teacher. This is your document. He does not get to tell you what your thoughts are. He does not get to tell you what your employment expectations are. This is your document. You present it the way you want to. So here are the common mistakes we see. First off is shortcuts in the investigation or relying on hearsay. Look, I heard this. I know it's true. I'm just going to jump straight to the chase. I don't want to play patty cake anymore. You have to try to get to the original source. You have to try to find out exactly what happened. Doing things like checking your video cameras, checking social media, that's sometimes seems like they're just slowing you down. You can find great stuff there that you maybe didn't even know existed. The flip side of relying on hearsay is ignoring hearsay. I'm involved in a situation, a student situation right now, where everybody and their brother wants to say what's hearsay. look, just unless you've gone to law school, you probably don't understand the hearsay rules. And that's not me being mean. That's just me telling you the truth. So if 6 different kids tell you that this happened, even if, or that Cody said this stuff, even if that's hearsay, that doesn't mean that you as an administrator are not entitled to say, overall, I believe this happened, right? If Cody walked up to a kid and said, I'm so mad at you, I hate this school, and one of these days I'm gonna get you, even though that is him, Bobby's reporting to me what Cody said, that can be an exception to the hearsay rules if Cody is giving you like his mental impressions and all this stuff. So I guess my point is figure out the best you can what was said, but don't be all so hung up on hearsay versus not hearsay that you watch Law and Order all the time and you think you know, that you don't rely on information that is important for you to know about in your building.
One quick thing to add, we hear it all the time. Well, you can't believe any of that, it's all hearsay. Number one, yes,
Yeah,
we can. We're not in court. This is a meeting with me telling you to stop being a jackass. Number two, hearsay is admissible in personnel cases.
Yes.
Now, the board is supposed to give it less weight than more direct types of evidence. But unlike a court where they could say, that's hearsay, none of it's coming in, these are, to the extent they're formal due process hearings, they're still just administrative proceedings. If that will come in at the board hearing, why would you exclude it from your reprimand document?
Everybody that's watching on the pin video, this is Cody who just walked in, who we've been talking about. So you see what a crappy employee he is. He walked out of the webinar to take a phone call. So we'll be putting that reprimand in your file. So anyway, yeah, if you're worried about like hearsay or evidentiary issues, honestly call your lawyer and have it be somebody that does a lot of teacher personnel cases, because hearsay is, we can do all kinds of good stuff with hearsay. Don't let that slow you down. The other thing that administrators sometimes do is they don't bother to get statements from the teachers or the kids or whoever in writing, especially parent complaints. If you can have a parent reduce that to writing, that makes life way better. So get everything written down that you can. Don't skip conferring with the teacher. Even if Cody is a pain, even if you know he's gonna lie to your face, you still have to sit down and give him a chance to tell you what he said. And then this one, I don't care if you show up with a draft reprimand, but if Cody tells you a whole bunch of new information and you just slide the reprimand across the desk anyway, that does kind of look like you've predetermined things. And again, the UniServe reps are starting to call us on it. So that's one option for Cody, is to give him a reprimand saying, knock it off, stop talking crap about the district. A second option is to go ahead and put together a formal remediation or improvement plan. So I'm gonna swap screens. And I love this cartoon. If you wait long enough, difficult people either quit, retire, or die. That's my management style. And that is an uncomfortably common management style of some school administrators. So you don't have to wait for them to die. You can do something sooner. So I am an old school, you know, when I was in teacher college, it was all Madeline Hunter. It wasn't all the new stuff that's Madeline Hunter with a new label. So I just love this quotation from Madeline Hunter. It's easier to help a poor teacher grow than to dismiss that teacher. Now, when I first got into the teacher termination business, I actually disagreed with that. I thought I started writing improvement plans to have better documents to fire them. But I don't think that's true. Oh, I'll look at this.
I've done this presentation with Karen where she's talked about this quote, and I know how she really feels about it. So.
It's true that if like you walk into a classroom, I think you pretty much know if the teacher's got it or they don't. I'll just be flat out about that. I am surprised, I will confess, I am surprised at the percentage of teachers that do get better when we put them on plans, even though I'd rather fire them. So here are some facts about remediation. They are not statutorily required, just like Bobby said, or whoever it was that said that.
You have to remediate them. You don't need a remediation plan.
You don't need a
to
formal improvement plan. But a surprising number of policies require improvement plans. And I'm just gonna drop a footnote here. If your evaluation policy says, anytime a principal marks a teacher as anything less than exemplary, he or she is required to write an improvement plan. To me, what your board is really doing is telling principals, give everybody an A+. Because there are times when you might want to mark somebody down and not do a full-blown plan. So I try to get rid of that whenever I can see that. But in some cases, there may not be a requirement to remediate. How many chances do we need to tell Cody to stop sleeping with kids in the parking lot? That would be zero, like that's a 1-strike rule, right? And so you don't always have to do a remediation plan. there is a teacher from Washington where the school found out that he'd slept with a kid. It was at a prior school. And so the teacher had gotten out of town ahead of the, the posse. And as soon as the school at the new school found out about this old event, they fired him. And the teacher sued and said, hey, I never was given any improvement plan. I never had a chance to, get better. And the court said, no, you don't have to be told 5 out of 6 opportunities you're not going to sleep with the sophomores. The court said the teacher's conduct was patently unacceptable.
Just sophomore.
I'm short of sleep, so I'm hilarious. But do be aware that if you're going to say we don't have any chance to make, it's so bad, we don't need to give the person a remediation plan, they're not going to get better no matter what, we have the burden to prove that. I think we can prove it in a lot of cases, but do know that we have to be able to back that up. The NSEA has latched onto this idea that a teacher has to be given a chance. They're going to sit in meetings and tell you, you are obligated to give this teacher a remediation plan. That's not true, but you are obligated to be able to go through the evaluation documents or some piece of paper and show that you've given the teacher concrete suggestions for improvement and a written list of deficiencies.
Another tactic they'll use in a hearing is, well, you could have done X, you could have done Y, you could have done Z. You didn't do any of those things, did you? Don't freak out when they did. You're right, I could have done those, I didn't do those. Here's educationally, professionally, why I chose not to do those. You get a chance to explain that away. You're the educational expert, you're the professional, so don't freak out when they try to say, well, you could have, yeah, I could have done a lot of things. It wasn't necessary, in my opinion. Here's why.
Yep, absolutely. And so that's exactly what Steve-O was saying there. Be prepared to answer why you used a formal plan in one case, but not in another case. In Sally's case, she had issues with lesson planning. That was something that, we needed to give her some additional instruction. In Cody's case, he knows to keep his mouth shut. He just chooses not to. So we didn't give him a remediation plan because we just told him to shut the heck up. But just the fact that they're asking those questions doesn't mean that you've done anything wrong. Just be prepared to answer them. I'm just going to swap screens. So I want to talk a little bit about deadlines. Every single time you give a teacher a directive, tell them when it has to be done by. And Trish Guinan, who's the director of advocacy now, has made this point really eloquently in closing arguments, and I've been kind of convinced by it, where she says, especially young teachers, they are used to a college system where the professor says, this is due by X date. So if you tell teachers, look, I want you to do a better job lesson planning, a millennial or a younger teacher might think they've got all semester to figure that out. And so telling them, I want you to use this lesson plan template and you need to have that in my office every Friday by 5 o'clock, that tells the teacher what you want, so it's better for the teacher. And it also is better for us because now we can prove that they didn't do what we told them to do. So every directive, even if you're making a suggestion, hey, have you thought about trying a behavior chart? Have you thought about trying this or that? I think you need to make a decision about implementing that by X date so that we don't have this just open-ended so the teacher can float around and do things. And so here's a great example of being specific. Saying you must submit me lesson plans timely. What timely means to all of us is different. We all know that Karen time is a little bit different than Sherry time or Bobby time. And
anybody's time.
Maybe Mandy's. But saying, as opposed to saying, you have to have them in my office no later than 4 o'clock every Friday, that's a big difference. And saying you have to do weekly lesson plans, like this is a huge issue we come up against all the time. When you say weekly lesson plans, if you want them by Friday, you damn well better say Friday, because otherwise the teacher's gonna have them in Monday morning at 8:15. And again, I meet the deadline, I never beat the deadline. So articulating what the deadline is, I think is really important. But here's the flip side. If you're gonna give teachers deadlines and hold them accountable, if you give yourself any deadline, you better meet it. This is why when I write remediation plans, I never give my principal deadlines. I say things like, we will be in your room frequently and give you constant feedback. But if you've written a plan that says, I will be in your room at least once a week and I will meet with you weekly to talk about what you can do better, you have to meet that obligation. Otherwise, the NSEA is gonna have a field day that you're holding the teacher accountable and not holding yourself accountable. And then if it's March and you are done with this teacher, this is not the time to put an improvement plan in place. What you have to do at that point is go back and look through your evaluation documents, see if you have enough to meet those Rule 10 requirements. A hurry up remediation plan makes you look sloppy and unfair. I would rather not use a remediation plan if the deadlines are too short, and just rely on the paper that you've got. But the NSCA will bully you and say you have to do one, and they know that if you do a fast one, it's going to make you look bad, so don't fall into that trap. So here is the pattern that we use for our plans. Each separate deficit is set out in a different performance goal. I don't like having more than probably 4 goals at a time. Personally, I prefer 3 because, you know, it feels holy. The heading is, you know, you will improve your lesson planning. And then the deficiency, when I've been in your room, your lessons often seem scattered and you're not prepared. Whatever it is that you've seen, tell them what they have to improve, give them a deadline, then list out the resources. So I've included a lesson planning template, or here's 3 articles from Education Week about the benefit of planning, or whatever it is you want to give them. Then tell them how you're going to assess their progress. I will review your lesson plans and make sure that they're meeting this template, and then the consequences for not meeting it.
I want to add one thing real quick here, not about the substance, but Sherry will send out a link after this that has like cut-ups of the video, the updated slides. We've also included several examples. Yeah. They're very similar to the ones if you attended this last year when Karen and Steve did it. But basically, it's some straight up samples from real cases where we've obviously stripped out the names and some of the pertinent facts for our ethical purposes. But you can see a lot of this stuff borne out. So I just wanted to remind everybody, don't feel like you need to jot all this stuff down. If you're doing that, we'll send out some actual templates of both remediations and remediation plans, reprimands, improvement plans, all that.
I would add, I agree with Karen on the performance goal. I limit those to, sometimes I'll go up to 5 depending on the teacher, but what I'll also do, I agree, the fewer you have, the better. But at the very end, I'll add something like, I also had concerns about all these other areas. However, your performance in the first 3 are so glaring and so necessary to address immediately that we'll get to those later. So that way they can't say, well, gosh, you only had three complaints. No, actually, I had about 20, but we're only going to focus on the top 3. So.
And the other, I love that you added that, because the other thing sometimes I hear is, Karen, I don't want to give her a plan because if she does all these things, we're going to have to keep her, and I don't want to keep her no matter what. So if you put those 3 things and then you add Steve's paragraph at the end that I actually have straight up stolen and put into some of the stuff I've written, it does make it so it doesn't look like no matter what the teacher did, you are always going to find something new. To own that at the very beginning, I think is really helpful. And then to hook onto what Bobby said, all the time here in the office, we say things like, I can't hear the music, or do you hear the music? It's so much easier to write these when you've read them. So looking at these examples, if you want to write them yourself, looking at these examples, I really think is invaluable. And that's why I don't judge you at all. I don't think it's a deficit as an administrator to call us and have us help you speak into them. In your career, you're going to write what? I don't know, maybe 1 improvement plan a year in your entire career. We write 50 a year. So it's just easier for us to hear the music. And so look at the examples, take a crack at it, but don't feel like we'll judge you if you need help, because we won't.
Some of this is the same stuff you can click through.
So yeah, no, I want to do this. Linking to educational practice and pedagogy, etc. I love to put in whatever your jam is educationally. I love to put some of that into the improvement plan, and here's why. If this thing does go to hearing, for example, I have some administrators that really dig Bloom's taxonomy. That's just something that they really believe in, and they think higher order thinking is the way to get students to achieve. I have other administrators that are very much into relational pedagogy, and they talk about student relationships and how that's just the most important foundational piece before a teacher can really be effective. You're not required to all think the same thing, but if I know what your jam is and we put that into the improvement plan, if this thing goes to hearing, I get to sit you down in front of the board and have you talk as an expert about stuff that you care about and you know. That just escalates your credibility in the hearing out the charts, but it also really makes you stronger with the board going forward on everything that you do. And so that's why I think it's worth taking the time to talk about what is your educational philosophy? What is your building? Are you a building-wide best? Are you PBIS? Whatever it is, I want to know what your pedagogy is so that we can make you look good in front of your board. Then list the improvement required. the methods of assistance, and of course, always the deadline and the consequences. So let's go back to Cody. We got a couple of choices with Cody about what we're gonna do. I think you probably should issue a written reprimand. Tell Cody that his actions have been unprofessional. Tell him that that is impacting your trust in him and his effectiveness in the building. See that this is more than just you're being an a-hole. It has actual practical impacts on our ability to be effective as an educational institution. So then Cody says, nothing. He's like, okay, fine. But Big Daddy shows up at the board meeting 2 weeks later and wants to intimidate the board. You're kind of concerned that the board's going to be biased because now father-in-law has shown his face and you think this thing might be headed to a hearing someday. And then after the board meeting, the UNICEF rep and Cody and probably father-in-law have gotten together and has written a scathing rebuttal to the reprimand that you get a week after the board meeting. Now what do? This is all still me, right?
This is still you.
Okay. So this is why I swapped the screens. I think that you need to look at the statute. This teacher is entitled to respond in writing, and you're required to attach it to the item that he disagrees with.
But
Now,
the reason this is of course a different statute than the reprimand statute.
Yes.
Because he's missed the deadline, right? We're now 3 weeks after you met and done the reprimand, so he's missed the grievance deadline and the response deadline.
but you
Can
don't get to rip that up and put it in the trash can.
Exactly.
So you have to attach it to the document with which he disagrees. And if anybody accesses the file, that has to be right there. And that's a game that the NSCA sometimes plays. They want to now look at the file, so they want to leaf through it. Just make sure that it's paper clipped together. Or if you have a digital file, make sure that you've made some kind of notation that there's a response.
Well, and this comes from Karen. We'll talk about the Bridgeport case later, but there was a teacher that went through on the eve of hearing and attached a response to every negative thing in his file going back 15, 16 months. And so the question is, and the board's question, well, why didn't you do this then? The short answer is this. You notice again, this is not the reprimand statute. This is not the evaluation statute where they have the ability to respond. This is separate and apart, and it says pretty much at any time they want to, they can go back into their file and attach a written response. So it doesn't matter if it's a year later, if it's 6 months later, if it's 3 weeks later. There's nothing you can do to stop that, but our opinion is you should always still have the last word if you can. So don't have them put things in the file that you're not also reviewing, and they can do that as part of their strategy preparing for hearing too.
Yeah, and one of the things that you do then, when they do this, you say, I directed you to respond within 7 days. You did not do so, so then I'm such a hag. You have been insubordinate because you did not file this scathing document timely. I will still include it in the file, but understand that I give it much less weight because you have chosen not to follow my directives, something like that.
Regardless of whether you agree or disagree that Karen's a hag for doing that, the union is absolutely having these types of conversations with their member.
Yes, they are.
You're not cheating. You're not playing gotcha by setting yourself up not to be caught in one of these and to prove to your board that, yes, I was on this from jump.
Okay, so let's talk for a second about the fact that we're worried that the father-in-law came to the board meeting. And we've had this happen too, where the teacher rallies the troops and comes to a board meeting, and then we're worried that the board is going to be biased, that the teacher is somehow going to be able to do something to make it so that the board can't give them an unbiased decision. So this is the statute that says the board is the one that has to actually decide whether or not we're going to cancel, non-renew, or terminate a teacher's contract. And then this is the wording from the Johansson case that talks about what does the board, how unbiased does the board have to be? And the Supreme Court said it has to be a tribunal that has an apparent impartiality, which makes me laugh because I don't know if that means they can know a bunch of stuff as long as they keep their mouth shut, or if it means that it's apparent to anybody that looks that they're impartial. But that's what the statute says in the Johansson case.
Not devoid of knowledge.
Right.
Although in fairness, we always err on the side of that because we certainly don't want anything from the administration or the school attorneys to the board to be the argument for bias. Much more preferable would be, yeah, they heard it around town. That's why I think we have this word.
Right.
They're not devoid of knowledge, but we always put in all of our correspondence, we can't tell you anything right now, but the standard is not probably as high as we work on the assumption that it is when we work with you.
And quite honestly, we've had, I don't know how many cases in a row where the NSCA attorney or representative has made a bias challenge of a board member.
Yeah.
And in several of those instances, we agreed, you're right, they are biased. And we made them one of the best witnesses we had in the case. And so it's not always a bad thing as long as we have enough board members left for a quorum and to get a necessary vote, it's fine. But they turned out to be some of the best witnesses because they have great information.
The other thing, and we have the Bridgeport case later, but this exact argument happened in that Bridgeport case. The teacher, and I can use his name because he appealed and put it into the public record, Patrick Robinson was complaining that the administration was treating him badly, and so he showed up in front of the board and complained about it. And then his lawyer argued that the board was biased because Robinson had come in front of the board and told them a bunch of stuff. And the Nebraska Supreme Court was just not buying it. They said a teacher cannot finagle the facts themselves to make it so that the board is biased and cannot take employment action. So I'm not worried about Cody's father-in-law in this case. Now, I would tell you that I probably would have, if you called me before this, you don't have to have public comment at every one of your meetings. And so you certainly could have gotten it so that father-in-law couldn't say anything, at least for a couple of months. But if you feel like you have to let father-in-law have his say, I don't want you thinking that they can now bias the board so that there's nothing we can do. So moving forward, I think, so this is like when you do a classroom observation, you're supposed to talk about what you see in the classroom, but that doesn't mean you can't include other stuff. So every time you do Cody's evaluations moving forward, in personal and professional, wherever that is on your rubric, but you have to have it, I would say, I continue to be concerned about the damage that you've done to your relationships within the building by constantly itching and stirring the pot. And I would just hammer that over and over in the evaluations. That is in addition to the reprimand that you've already given him, right? So this reprimand can do multiple duties. It can be a reprimand. It can also be the basis for you talking about it moving forward in Cody's evaluations. It shows that it's a really big deal. Sometimes if you reprimand and never refer to it again, the teacher assumes that everything's fine and hunky-dory, and then it feels like cheating when you bring it up later. And it also fights the NSCA hearing tactic. Now, see, I don't care about this. The NSCA will say, did your lawyer prepare this document? First of all, we never do the first draft of the classroom observation. I want you to do that first draft because you saw it. But us doing a first draft of a reprimand, that doesn't give me any heartburn at all. So did your lawyers prepare this document? I conferred with legal counsel. They prepared a draft, but the thoughts in here and the ultimate conclusions are mine. And in the meantime, we're losing our minds objecting because of attorney-client privilege. But I don't want you, so sometimes it's a gotcha move to make you look scared and uncertain. Yeah, of course I conferred with my lawyer. What do you think this is, my first rodeo? Screw you, of course we call. Did the teacher call you, Miss Union Rep? Yeah, she did, so there you go.
This is part of Karen's thinking throughout this, we'd be talking about it. This is a tactic that they use.
Yeah.
Just to try to get you flustered on the stand.
Exactly.
And I find it amusing just because their representatives write their responses to reprimands. Their representatives write responses to evaluations. Their representatives write requests for hearings. Teachers don't do those things.
Right.
And so both sides are doing the same exact thing, and there's nothing inappropriate about it.
So yeah, just don't freak out. And then with Cody, I'd start building the case for non-renewal because I don't think Cody's not going to get better, and it's going to be harder when he's tenured than now when he's a probie. So I would start now obtaining statements from staff members. Here's why. If you wait until he's made a hearing request and you're like on the eve of hearing, they're super freaked out. Getting them to put stuff in writing now, at least you've dropped anchor and you have, what Mrs. Johnson said that Cody said in the teacher's lounge.
When you're preparing for a hearing and those teachers that were really strong when they came in 6 months ago talking about how Cody's damaging our culture, suddenly they get this, scaredness that kind of comes over them. They don't want to testify. They don't want to talk to you. Having something in writing from the time when it actually happened is the easiest way to tell them, we're going to introduce this because I think what you said here is true. Is any reason that it's not true? Well, no, I just don't want to testify.
Yeah. And if you really have somebody that just truly just doesn't have the gumption to actually testify, we at least have a document that we can now fight about whether it gets in at the personnel hearing. So getting it in writing, even an email, that would be fantastic, but 100% get it written down. Any parent or student that complains, get that documented. Again, typically people don't want to sign anything. They feel like that's, Cody's going to target them or go after their kid. But saying, hey, could you jot that down in an email so I know I've got it? I'm going to make some notes, make sure that they're correct, but somehow try to document parent and student complaints. You can, so the idea of progressive discipline is one that I don't really care that much about, but if you want to have progressive discipline, it's pretty easy to put that together here, right? One, Cody, knock it off, and then put an email together. There's your oral reprimand. Two, you issue Cody a written reprimand. Don't ever do this again. And if it continues, Cody, I'm reprimanding you, and I'm sending you home for 3 days for you to consider your misconduct and come back with a renewed sense of purpose. That shows that you're, making it get progressively harsher. And then you might consider an improvement plan. I love making teachers read books to change their hearts. I don't know if it ever works for them, but it makes me feel better. So, read a bunch of John Gordon, read a bunch of, like John Maxwell, stuff like that. I like doing that. And then I make them write reflections. And so here's the thing. If Cody's writing these reflections and it's stupid, he shows that he thinks it's stupid, and his disdain for the district comes through loud and clear. Those are fantastic exhibits in a personnel hearing. If Cody really is, struggling, I just was reading a teacher had been made to write reflections, and the teacher wrote, I think maybe I should make some friends. Like literally, she wrote that in her plan. It's like, holy crap, yeah, you might, maybe some therapy. Making the teacher read this stuff, even if it doesn't change their heart, it's still an extraordinarily useful exercise for us as the attorneys. And if it really helps somebody get better, so much the better. So that's what I would do with Cody moving forward. This is a problem we're gonna have to manage. We're not gonna solve it immediately, but long-term, I think Cody's going bye-bye. Because I don't think he's ever gonna improve his attitude.
So that's it. We're at about the halfway point here in the slides and what we're planning to cover. It's 10:21 on our end, so we'll probably, what do you think? 10-minute break?
Yeah, let's
download coffee, and then our hope is we've got 3 more hypos, but those will go quicker. We did a lot of the heavy lifting here, and so our hope is that then we'll come back, probably see if anybody has any questions. Yep. Then we'll jump into our last few hypos and finish up with some of the cases about what the courts have actually said about some of these issues.
So 10-minute break to be back here at 10:30. Okay, hopefully everybody had a scintillating trip to the bathroom. I will tell you, here in the Cornhusker, they're having like I think it's a PE teacher conference. So in the women's bathroom, there's all these like young women in yoga pants, like and they've all been doing aerobics, so it was a little bit discouraging to wander in there in my grown-up clothes and see all these young teachers that are like literally playing games at their conference. So we walked in this morning, my husband came in with me and he's like, I don't know what conference that is, but I want to attend it. So, okay, so I think this brings us up to Mandy, who will pop in here. You'll see her in the back. She is our other new hire, and it's the Just Not Good Enough, Estabano. This is you, right? Is it Robert or is it me?
This is me.
Okay.
Okay. So just not sorry. We totally had these divided out. That's my fault. I don't normally pull a Karen. Okay. So this is the case of just not good enough, and this probably is the one that we see where you don't really know if you should call, and then we get the call in March, and it's like, wow, all the evaluations are good. Okay. So let's say that Manny hypothetically is a third-year teacher. Whose evaluations, there's no doubt, you would rank as the bottom third on your staff. So you're not saying she's the worst teacher, but you also know this is the last year of the probationary period. Mm-hmm. She's nice, she's smart, she understands the material really well. It's never been a question of her competence with respect to like understanding and knowing the English curriculum. But the fact of the matter is she's never been able to control the room. The high school kids run all over her. And her AP and honors classes go pretty well. Generally speaking, well-behaved kids who are doing the homework and trying hard, but she's really struggling with all of her classes that aren't either AP or honors. You have parents on both sides of the issue. And in fact, you have recent graduates that are on both sides of the issue. You've had this teacher, right? Some think is the best teacher in the world. Every teacher's helped somebody, but you've got some kids who especially were high-performing kids where she was able to meet them intellectually on their level, and especially in some of these advanced classes. And you've got parents, though, that have come in and said, my kid's struggling. She doesn't stop to differentiate. It's just not going well for my kid. So you're in the second semester of her third year, and you start going, maybe you call a school lawyer and you start going through evaluations. 10% of her evaluations are exceeds district expectations for things like mastery of the subject area and those sorts of things. 75% of all of the categories you've ranked over the last 6 evaluations are meets expectations. 10% is needs improvement. So needs improvement, you're going to say, well, clearly, I told her, I really hammered her on this one, Karen. I put needs improvement. But when we go through and look at it, only 4 of the evaluations or only 4 categories of the however many domains you've had, have you ever actually said that you're not meeting expectations and district standards in these cases? So the superintendent's been pushing for things like cultural improvement. It's just not, and it's making a difference in the school. There have been several teachers who have been sort of gently nudged out by the superintendent because the superintendent's trying to do things differently and improve things like test scores. So the superintendent comes into your office, closes the door, and sits down and says, Mandy's just not good enough to be an Eagle. We put Eagle in there. I don't care if it's Duke, Cardinal, whatever it is. But this is the case that we call just not good enough to be a
And let me just throw a footnote out here. If you can't imagine your school district having somebody that's not good enough to be an Eagle, then I think you should have these cases, right? I think it is 100% acceptable to say, she is not so incompetent, no school would ever hire her. She's not good enough for us. And I think I want to affirm that that is the kind of administration I think makes Nebraska schools better than other schools. So
yeah, definitely. And so the bottom line is, let's say that you're either a newer principal, or even if you've been doing this for a while, you're sitting there thinking, well, that's easy for you to say, Mr. or Ms. Superintendent, but it's my evaluations that are going to be on the line here. It's me who's going to have to answer these questions about why they were so good if she was clearly so bad that we had to fire her and force her and her family to move and sell her house, and you can see it developing. So the superintendent says, all right, well, to the extent I wasn't clear, I think we have to non-renew Mandy. So if you want to switch to the statute real quick, this is the part that Steve was talking about. Any reason, so long as it is constitutionally permissible. So in other words, if your basis for non-renewal is anything but unconstitutional, it's lawful. They write it in a sort of a confusing way, but although you still have to have some rational basis for making your decision, it can't just be completely arbitrary. I don't like that, that she wears blue shirts.
I believe you can say, I don't like that she wears blue shirts. I think that's arbitrary, but I think you can say she only wore Eagle gear 3 Fridays out of all football season.
Yep.
That's permissible.
Think back to what the statute actually says about non-renewal. If you go back and look at it, their chance to show up and present their side, right? The statute wasn't contemplating this big back and forth with cross-examinations about whether you knew Rule 10 or not. The statute's contemplating y'all show up and give your pitch to the board,
yep,
and the board decides if Mandy's good enough to be a Cardinal or not, right? And so that's why we sort of step back sometimes in these cases and say, okay, what does the non-renewal statute actually say? How did they envision this process playing out? And although the hearing will be more formal, there's a reason that it says any reason so long as it's not unconstitutional. So the question of who issues the notice comes up a lot in these cases, or what if you disagree with the superintendent? The fact of the matter is, the statute says, although it doesn't, I think the way the statute should be read is the school board can issue a notice to a superintendent, but the superintendent or superintendent's designee are the one that issue the notice to the affected certificated employee if it's a teacher. So if the superintendent says to you as a principal, you're going to issue a notice, it's difficult to think about how to process that case, but the statute would allow the superintendent to issue the notice even if you didn't. So I think having clear communications about your concerns with the case with your superintendent is a much better choice than saying, I disagree with you for you professionally, but this is what the statute says. The superintendent can issue it even if they're not the evaluating administrator.
So but go back up.
Yep.
So the superintendent must deliver it unless the board has formally designated or there's some paper that says somebody else can issue it. We've had this happen where the principal or the HR person in central office issued it, and we need some kind of written document that shows they are the designee. When in doubt, have the superintendent issue the notice.
Okay, so let's say that Mandy does, you go through, you include the things that you're required to include in your notice of non-renewal, which again, is not much. You don't have to give Mandy, unlike a cancellation or termination, a big list of all the stuff. You just have to say that the board's going to consider a non-renewal of your contract. So Mandy gets that. Mandy requests a hearing. In preparation of the hearing, you're working with the school's lawyer as you get ready. You read all the evaluations. You read the rest of the personnel file. If we're prepping you, and I'm sure your school lawyer would too, if you don't work with KSB, is going to have you look at things like your evaluation policy, make sure that the correct instrument was on file with NDE, make sure you use the correct policy, look through Rule 10, right? We're going to force you essentially to remind yourself of all those things that you're expected to know as an expert in evaluation. So you're there at the hearing, you feel pretty confident. Earlier that morning, we went over your testimony and you're ready to roll. And then all of a sudden you see the NSCA start to cross-examine the witnesses that go before you. And you're thinking, wow, that's a lawyer on the other side who is here, and maybe their sole purpose. I've had this hearing, everybody's had this hearing. The sole purpose is the teacher says, I don't care if I get fired, I want you to make that principal look bad. That is a lawful reason for them to hold the hearing. They don't have to tell you why they're doing it, but you're sitting there getting a little bit nervous as the examination begins. So what will typically happen is we would call you and we would go through your examination. We'd walk through how you're an expert. If there were glaring holes or weaknesses in the case, we'd try to cover those on the front end, give you a chance to explain it before you get hit with the cross-examination question. But inevitably, we're going to say, okay, that's all we have. And you're sitting there and the union lawyers to your right, and now you've got to start answering their questions. So we're putting these up here not to scare you into never having a non-renewal hearing, even for a not good enough type of case, but just to tell you that as you're documenting things some random September afternoon, it's a good idea to know and at least have in the back of your mind what that document would look like in a hearing. So questions that we've heard or tactics that we've heard from the NSCA. So number one, are you the administrator certificated to perform Mandy's evaluation? Seems like an innocuous question. Yes, of course I am. You hold the right credentials from NDE? Absolutely. Did you evaluate her? Yep. Explain the requirements of your evaluation policy to the board. If that flush comes over your face, it's because you clearly have not read your evaluation policy in preparation of the hearing. Now, as you sit there today, could you explain it? How would you answer this question, especially as a principal? Even as a superintendent, right? Superintendent, you're going to go on after the principal and answer similar sort of questions and sprinkle the magic blessing of the chief administrator on the principal's actions here.
So
No, please,
things
please.
like we use Danielson, we use Marzano. That's not enough, right? You're going to have to say, you know, Robert Marzano has done research on classroom instruction across thousands of school districts, and he has distilled, I think it's 64 specific elements that show effective instruction. And so our policy takes those 64 and bundles them up into like 10 domains or whatever it is. That's the kind of stuff we want you to be able to say. It's not hard. You can do it. I mean, I know you can do it because when you've had a couple of drinks at administrators' days, you say this kind of stuff. You just have to be ready to say it in a professional manner in front of the board.
And that's why I in particular have started to add a lot more of this to the prep. So you might be thinking, holy crap, I must have missed something. Why on earth would this union lawyer be making me go through the evaluation policy if I missed something?
That's right. It is a way to rattle you.
They are not they don't necessarily have anything that you've done wrong. They're just trying to get you to start questioning yourself. So reviewing that beforehand and understanding, maybe they add to this, so you owed this teacher 6 evaluations, isn't that right? That again, they might be asking that to freak you out. Now
But
you're
don't
like,
answer that question. Yes?
Exactly, exactly.
Karen and I have had a couple of hearings together where they start to go down this road and we look at each other going, what are they doing? And, uh-oh, are they going to get something out of this policy? And then they ask this question and kind of go, aha. And we look at each other and go, hey, you proved the sky is blue. Congratulations.
Right.
It happens.
All the
And
time.
why they do it, I don't know.
Yep.
It doesn't make much sense to us. So just answer the questions that are asked and don't worry about it.
Yeah, absolutely. One more small point to make here. We're not here to rail on Danielson or Marzano or NDE's form documents or their form policies for evaluation. I get that the purpose, our statutes make clear that the purpose is for you to help improve struggling teachers. The more that's in that policy that you have to do, the more it is possible that there's a step in there that you could have missed. But again, that's part of the prep phase. So answer the questions confidently. Now, what if you do that really well and they say, okay, so you're an expert in evaluation. Explain to me the requirements of Rule 10. Well, the reason we put the statute, the Rule 10 or the rule sections in there is it's not so much to master if you read through it 20 minutes, you know, and in preparation for the hearing. So we're going to help you do that. Okay, and so then they start to attack the individual aspects of it. So you ranked, Mandy, 120 separate times in these documents, right? So maybe this is what they're setting you up for. Let me see, 6 times, yes, I did. 20 in each, yep, I sure did. And only 4 out of 120 times you said she fell below district standards. You need to be thinking about, yes, that's absolutely true. That was 4 too many. Or whatever your answer is going to be, they're going to start looking at stuff like that. So again, we'll help you through it.
And I've started to go back one. I've started seeing, especially in the element heavy, Danielson and Marzano, I've started seeing districts include in their board policy that no one of these is particularly important. There's no ratio of good to bad. There's no tipping point. Kind of that basically says the administrator gets to say which one of these is most important in any given case, which I kind of like that language, and I've highlighted it in the policy of a hearing I'm getting ready to go to for that very reason.
Yeah. One of the things that I had happen last spring, and we ended up able to work it out, but was in the evaluation policy. The administrators clearly used the right instrument. They had the right policy on file, but it said any time you mark does not meet expectations, you're required to move into level 1, unless it's so bad that you have to move into level 2. And then if they don't exceed, you have to move into level 3 and then walk through the candy cane forest, and then you can fire them, right? So the teacher in that particular case had never been given an improvement plan because it was truly, and only 4 out of all the 6 documents that she'd ever been given as evaluations, only 4 of those domains were ever below standards. And of course it had flowery crap in there about, we really wish you would improve here. You're doing great in other areas, but this is one where you really struggle. It did not make it seem like it was a significant deal. And so number 1, we can explain that away, but if you have a policy that says you'll remediate them with a plan if they ever have a does not meet, and that's not in the paper, we're going to tell you that that's a way for them to challenge at this hearing, even if she's not good enough to be a cardinal. Another series of tactics. How many other teachers are below district standards? So as part of the prep for these, we've all started to process through the fact that the NSEA can talk to its other members and say, how many of you are on plans? Have you ever put any other teachers on an improvement plan? Well, sure I have. Did you ever put Mandy on an improvement plan? Well, no. Why not? Doesn't she deserve your best efforts to improve her? Wouldn't you agree that an improvement plan is an increase? So these sorts of gotcha, why didn't you do this? This is part of what we're talking about. Trust yourself, trust your processes, but understand if you're sitting there thinking, or you're talking to the lawyer, in March of the 3rd year of the teacher, do we have this? We're going to ask you these questions, not because we think you did anything wrong, because the union's going to. So in summary here, it's the NSGA's job to create doubt. Chad Meisgeier, who we really like, told me I really like Chad. Oh, you got it. Okay, yeah, there we go. Sorry, you got the cartoon in there. It's the NSCA's job to sow doubt in what it is that you're doing. There's a flaw in every case. I think if you asked Scott Norby or Nick Welding or any other lawyer that's ever represented teachers, or Trish Guinan in these cases, they'll say, and it's true, every case has some sort of flaw or something in there where we can start to poke holes in it. That doesn't make it unlawful. You don't have a beyond a reasonable doubt standard like you would in criminal court. Your professional judgment is entitled to deference, but you need to remember it's their job to make you look bad. Don't be afraid to ask help from legal counsel in reviewing plans. This is why, right? The NSCA is going to pull out tactics like this. This is why we've stopped caring if they ask if you sought legal counsel to help prepare these documents. And remember the standard, it's not that you have to be perfect, it's that we have to have some reason that isn't unconstitutional. So when you have these just not good enough cases, don't be afraid to say that teacher, although is not the worst teacher we have, is not good enough for our kids, because the legal standard says what it says.
So just a quick note about getting crossed. There's 2 extremes, and I don't want you to go to either one. One is the pause up, please just don't hurt me anymore. I'll admit whatever you tell me to admit. That's where I try to get all my witnesses. Just make the bad lady stop asking me questions. So if you're getting hammered, you've got to keep your what do I want to say, your dukes up. Don't just give up. I don't see administrators doing that as often as I do teachers. But the other extreme is to look like an a-hole. Yep, that's what it says. No, I don't think she needed a plan. It's good enough. Good enough. You want to look like Dudley Trueheart. Well, I considered putting Mandy on a plan, but really her issues were more about her innate abilities to form relationships with kids who struggle. And since here, all of our Eagles are excellent kids, but we do have a lot of families that come from difficult socioeconomic circumstances. So I don't know that a plan was really the right thing for Mandy as much as it is letting Mandy go someplace where she can find success in a community where she's going to connect better. That's way better than looking like a tool, right? And so, but you got to just constantly you cannot check out and get mad. And the only time I don't object very often during personnel hearings, if I'm objecting a lot, it means either I think you're getting mad and you need a chance to catch a break, or I want to make some point to the other lawyer. But you've got to keep your brain engaged the whole time.
And we put this up there, and that's a great point. The whole purpose of this section is, we've already covered the non-renewal stuff, right? It's to tell you that the NSEA's purpose, every time you're writing every evaluation instrument you do, we wish at some point in the back of your mind, it was, okay, so let me think about how this is going to look in a hearing.
Look
And
at
I think
everything backwards,
once
right?
you've been through a hearing, I think that probably makes sense. If you ask anybody who has, they will tell you it changed how they documented.
I think this is also why if there is a personnel hearing within 150, 200 miles of you, you should go. I think every administrator should go and watch one of these things because we can explain it till we're blue in the face. Until you see it, it's just hard to understand.
And the more you see, the more you learn. I mean, we're
Yeah.
20 years in and we still learn something from each hearing and from interacting with the various people that are involved in a hearing. So it's a tremendous learning experience.
It also makes you, I think, less afraid to go.
Yes.
Yep.
So, okay, so what are we gonna do if we have it?
Well, I mean, that's it. It's your choice, right? We don't have like, okay, what are your options? Your options are to let her get tenure or to non-renewer. And so to some extent,
And I have never once had an administrator call and say, you know what, Karen, we were considering non-renewing. We are so glad she got tenure because she's way better now that she knows she can't be fired as easily. I've never once had that
Shocking. All right, the slap heard around the school. We're going to move on to a tenured teacher. We got Matt, he's a 10th year, 5th grade teacher who's also the wrestling coach and assistant football coach. So that always makes it fun because coaching is obviously way more important than teaching. At least that's my experience based at hearings. Matt's wrestling team returns 4 state police winners and a state champ or state place winners.
got a shot this year.
Some parents have complained about his harsh tone, his Bobby Knight approach with his team, with his 5th graders, and the loud rap music he plays at practice.
Okay, so this is Matt Russell, who's our driver, who loves him some loud rap. So that's hilarious.
On the way back from the building to the modular, the students in line are told to stop at the door and don't open it yet. Matt's standing on the platform, which leads into the building. One student drops his books and is picking them up. The papers begin to blow across the lawn. The student in the front of the line is known to make trouble on occasion. We'll call him Bobby. The student grabs the door handle lever and starts slamming it up and down. Of course he does. Matt's frustrated, turns around and slaps the hand hard and makes contact with the hand and the handle.
So you can see this happening, right? The papers are blowing across. There's nobody else out there to supervise. Matt's deciding, am I going to jump the railing and help the kid with the papers? Or am I going to stop little Steve from trying to get into the classroom when I told him not to?
And so the student immediately begins crying and yelling that his hand hurts so bad. The scene causes several other staff members from inside the building to come out to the modular. Matt, still angry, says, kids these days aren't taught to listen to authority figures. Preach on, Matt. You can get a call from one of the staff members who is called from her cell phone at the scene. As you arrive, Matt has finally calmed down, but the student's still crying and saying his hand is broken.
I just can picture this kid in my head so perfectly.
You know what? This kid knows the system. They know exactly what to say.
Yep. Bobby the drama queen. Okay. You inspect his hand and do see there are red marks from the edges of the door handle lever. All right, so what are we going to do first? The first issue that we always jump to, especially these days, child abuse.
Yeah.
And so do we have reasonable cause to believe that the child has been subjected to child abuse or neglect? I mean, this probably is. I mean, he's been assaulted. And so we're in the better safe than sorry time in society. You don't want to put your license on the hook for failing to. So you address it from a school district perspective. You also have to address it from the child abuse perspective. And so it very well may be that you have to call this into law enforcement with a toll-free number. As an aside, if you want true action, call your local police department. Yep. That toll-free number, it's a number out of Omaha. They don't know your town. They don't know anything about what you guys have going on. So I would call local law enforcement on that.
Well, so here, just one quick point, because we get this question, and I think as an administrator, it's fair to think about the politics. I think you have to. What if we know we need to make a call, but if we call local law enforcement, they might do something because they don't like Matt. But if we call the hotline, they'll never send somebody out because a kid got his hand slapped. It's your choice, right?
Or we'll call local law enforcement because we know that the chief's son was a state wrestler 2 years ago. So we know nothing's going to happen.
You are required to make the report of child abuse. You cannot skip that step. But we understand
But you
the
can
political
pick where
questions,
you call.
right?
Rule 27 reporting, each certificate holder shall report to the commissioner any known violation. And so this requires you to be a lawyer or a county attorney and figure out down below. So you have to report revoked certificates, obviously not this, misrepresenting professional qualifications, nope. But that subsection E, certificated people cannot commit any act of moral turpitude. Child abuse probably is not going to fall under that, or any felony under the laws of the US or any state. If the child abuse was significant enough, it could be a felony. And so that's something we have to look at. In this case, we're not going to get into the statutes, but this would not be felony child abuse. And so that's just having knowledge of that act being committed. It doesn't require a charge. It doesn't require conviction. It just means it had to have occurred. And we've recently had a case where it seemed like NDE was ratcheting up the expectations of your knowledge about what's a felony and whether it's been committed and whether it's a known violation. So keep that in mind. This seems to be a rather hot issue over at the department, and we're told there will be some sort of guidance issued. I hope that's accurate. It's I think the plan is a frequently asked questions kind of document in plain English. So you'll have a better idea of what am I supposed to report? When am I supposed to report?
The department's view right now, though, is when in doubt, report. And
Yes, no
I hate
question.
that, but that's what their guidance is right now.
So I think the reason that what this does and the reason we put these before any of the personnel considerations is think about what has already happened. You've called and told the police on that. Now you've called
Because you have to.
Because you have to. Now, at least the way that I think NDE is reading this stuff, you've now called and made what amounts to an ethics report. It's no different than if one lawyer called another in and said that one did something unethical. That's how Rule 27 applies to educators. So you've now done two pretty major things that you didn't have a choice to do or not to do. And that stuff's probably happened immediately before you even start processing the personnel case. So you want to talk about the community's riled up, Matt's already riled up, but there's nothing you can do to stop any of this stuff from happening.
Yeah, it's required.
I
So
hate that.
You're seeing it's becoming a three-part process in many of these personnel cases. The last part of that is if you have a misdemeanor conviction. So maybe you didn't know it was a felony, or maybe it wasn't a felony. But once there's a misdemeanor conviction and you have knowledge of it, and it's related to abuse, neglect, sexual misconduct, you have an obligation to report that. You don't have a choice.
Do you want to talk about putting in the obligation for them to tell you that they've been charged to the contract?
We do put that, many of you will have a policy that says this. We put it into our form teacher contract that the NSCA is not a fan of, at least one version of it. But it requires them, if they are charged, if we make it as broad as possible, if there's any chance that they're going to be charged with child abuse or they have committed child abuse, they need to let you know. And if they don't, that's a breach of their employment contract. Number one, it's just important for you guys to know if a teacher's committed that kind of act, we have to determine, is this an appropriate person to be in our building? But two, it also goes to the employment purposes of are we going to take action on that? But we don't want you guys to be caught flat-footed. We don't want the board to be caught flat-footed. You should learn about this before you see them on the 10 o'clock news. That's kind of where that comes from. Corporal punishment, as all of you know, it's prohibited in Nebraska in public schools. You can't do it. We had the Daly case where they defined corporal punishment for us, and it hadn't been defined until 1999. Interestingly enough, it was debated on the floor of the legislature, and Ernie Chambers had put this in, and he says, well, you'll know it when you see it. So there was no definition. So it's reasonably understood to be the infliction of bodily pain as a penalty for disapproved behavior. Infliction of bodily pain is a penalty for disapproved behavior. So that's what our definition is. In this case, was there infliction of bodily pain? Yeah, the kid was screaming out and thought his hand was broken. Was it a penalty for disapproved behavior? Yeah, it was. We have corporal punishment. Now, interestingly enough, corporal punishment is not necessarily a mandatory report. There's going to be a lot of crossover, and in many cases, it will be a mandatory report. But just corporal punishment by itself, not, and maybe that'll change at some point. But
I want to jump in with this definition. Mandy and I were just at the activity directors conference yesterday. This is something that I talk to them about every so often, and I'll probably put it in my deck maybe for next year. But I want you all, if you do double duty as the AD or if you supervise the AD, I am really worried about this idea of infliction of bodily pain as a penalty for disapproved behavior. Doing up downs until you learn not to jump off sides, or running steps because you got an unsportsmanlike conduct penalty last week, or you missed that block as the volleyball player, and so now you're gonna have to do push-ups until you can't do them anymore. We don't have a case that says that, but as I look at that definition, the infliction of bodily pain as a penalty for disapproved behavior, I think we need to have our coaches know this. And I've had 2 PPC complaints against coaches for allegations that they were too Bobby Knight-ish. And so I just want you to put that definition in front of your coaching staff so they know this is what the Supreme Court says is corporal punishment.
So what to do first? Obviously, take care of the kid's injury, make sure he's all right, get somebody else involved if that's appropriate. Document the red marks, the cuts, etc. Take pictures, take videos if it's appropriate. That
And you
comes
don't
in
need
very
parent
handy.
consent for that.
Correct. Contact the parents. Be careful of the personnel file confidentiality. We'll show you a slide here in a minute that'll get into that. And that can be frustrating at times when the community wants to know what's going on, the news contacts you, wants to know what's going on, the parents contact you and want to know what's going on. There's some limitations on there. Find someone else to supervise the class and put Matt on administrative leave. Again, you can suspend them with pay pretty much as you see fit when it's appropriate. It's at your discretion. So here's the personnel file confidentiality provision. It basically says the teacher or administrator gets access to their file and they can give written permission to people to have access to their file. But no other person except school officials while engaged in their professional duties shall be granted access to the file, and the contents thereof shall not be divulged in any manner to any unauthorized person. Compare this to FERPA or the student records exception. FERPA has kind of a similar provision, but the family, the FPCO, the people who supervise that statute and enforce that statute, there's an exception under the rules. If you have personal knowledge, you saw it yourself, that's not revealing the contents of that student's file. That's giving out your personal knowledge. We don't have that same kind of exception here for our personnel statute. And that makes it very difficult. You know, if the teacher says, well, did you suspend him? What are you going to do? You going to fire him? Well, if we're in the midst, if we've given them notice, we can't tell them we notice of the teacher. That's confidential until there's a board action or a scheduled board action. And so it can be a very difficult situation to be able to relay to people, yes, we're taking care of this, but we can't tell you. And it's one of those things of, you got to trust us. That doesn't often go over very well with communities, especially in smaller communities where everybody kind of knows what's going on, but they want to know what you're doing.
We can say that so-and-so is on leave because they're not in the classroom. Parents are entitled to know who's going to be in the classroom. Other than that, you literally can't say anything.
So the way that I think this plays out is you call the parents, hey, there was something that happened. What are they going to say on the phone? Well, how did he hurt his hand? So it's always a little bit awkward because if you haven't yet documented, then technically there's no document that exists, but you know the contents that are going to go in that document are clearly what happened, that Matt, the teacher, slapped the kid's hand. So does that allow you to share with them before you document it? Does it tell you that you should call the parents? So those are all questions that I think you should call and sort through. And frankly, as your legal counsel, we're going to ask you things like, well, how are these parents going to react? Are they going to overreact? Are they going to underreact in terms of addressing that?
The other thing that I do sometimes is write up a little report to put into the kids file. Now we've created a FERPA protected document, and parents are entitled under FERPA to see the contents of their kids file. And then whatever we put in Maddie's file separate, that's the personnel file part of it.
And remember, whatever you put in the kids file, the parents get a copy of,
Yep.
so they can take that to their lawyer, to the police, to anybody they want. So that's not to, I agree with Karen
Just-
completely,
yeah.
but
Through
practically,
it.
practically that's how you get them the information, but that has a significance then if they're going to take that and probably post it on Facebook.
Yep. Oh, 100%. And they're going to take pictures of the kids' hand. That's why you should take a picture, because they will.
So here's the statute that talks about reasons for cancellation or amendment. You'll see down there, unprofessional conduct is on the list. I think this obviously would be unprofessional conduct. We also have breach of any material provision of the teacher's or administrator's contract. That's why I like to put that provision in there, that they have to give us notice. So if it happened outside of school and they don't tell us, that's reason to cancel it.
So anything in there, so when you're looking at, those teacher contracts all say, for whatever reason, we just use everybody still uses this form, first, second, third, fourth, and it says things like comply with every school policy and that sort of stuff.
That's that one.
Yeah, there we go.
Yeah, and so we put those provisions in there and we can use those against them. I mean, it's a breach of their employment agreement.
So this is how we get committing corporal punishment to be an admission of a breach of their contract, because we've got a board policy that says we can't do it. So even though corporal punishment isn't in the list of the statute for cancellation, you could do it by saying we've got a policy in contract, you agreed to comply with policy.
And you can see this provision, the very last one, subsection J, any conduct that interferes substantially with the teacher's continued performance of duties. This may or may not reach that level. What history does Matt have? Was this the last straw? Has he used other kids? Has he touched other kids? Or was this the first incident? And so those are factors you could weighed to determine whether this is going to interfere with his ability to continue at the district. The procedures will.
Can I, sorry, I want to go back one. So there is an attorney in this state that says you cannot win a corporal punishment cancellation case west of Kearney.
That may be in the slides.
Oh, is it? Okay, so I'll be quiet. Okay, go ahead.
So here's the cancellation process. And again, we put these in here so you can take a look at the statutes. And you can go back and read those when we're done. We'll summarize them here. Here's our summary. So again, it's the same concept as a non-renewal for a probationary teacher, except cancellation is a little different. They get even more due process. You have to give them notice of the alleged grounds for cancellation in that initial letter. In both cases, if they ask for a hearing 5 days before a hearing, we have to give them a lot more stuff. But in cancellation, you even have to go further than that initial notice for a termination or non-renewal. You've got to tell them the alleged grounds.
Now, and we kick around as attorneys, whether that is just immorality, neglect of duty, unprofessional conduct. We, as a firm, think that they are entitled to more. They're entitled to the facts, not just the legal conclusions.
And so we'll put that information in there. Same thing. They have 7 days to make a request for a hearing. The notice of reasons for cancellation, witnesses, exhibits 5 days before the hearing. That's the same where they get that. We call that the disclosure letter. That's where they get all the goods about what it is we're going to present in the hearing. The matter is confidential again, just like it was last time, until a hearing or court action is scheduled. 30 days to hold the hearing. The formal hearing is as follows. So this is a little different than the non-renewal procedure for a probationary teacher. It's formal. By statute, it's formal. The notice has to comply with the Open Meetings Act. The administration board and teacher are represented by lawyers. There's presentation of evidence. It looks a lot more like a court. Again, they're going to look similar, but this statutorily would have to look a lot more like a court hearing. There's cross-examination, and actually, with most hearing, there's some exceptions, but most hearing officers will let the school administration, the prosecution, ask as many questions as they want, and they'll let the teacher's representative or attorney ask as many questions as they want. It'll go back and forth. In a court hearing, really, if you wanted to be strict, it would be direct, cross, redirect, you're done. But we tend to be a little bit softer on that in the personnel hearings. The decision has to be based solely on the evidence presented at the hearing. You can't take in that extraneous evidence. Remember, you have to be unbiased, and you have to only listen to what the evidence is at that hearing. This is a significant difference from the probationary teachers. It's a majority of the members of the board must vote to cancel the contract. So 4 votes on a 6-member board. And so that occurs no matter what. And so what Karen and I have both had hearings here in the last 2 years where the board members, as we said, were disqualified. They were biased. They couldn't be on the board. I had one where one board member was disqualified and one just happened to not be able to make it to that hearing that night. Don't be that board member. But anyway, so we had four sitting board members. We needed a unanimous vote to have that cancellation go forward. And that's the seat it puts you. You can't get 3 out of the 4 votes. You need all 4 votes.
And you need 4 affirmative votes. You can't have a abstention.
Yeah, no abstentions. No funny business. It's 4 votes of yes, I want to cancel that teacher's contract. The board obviously has to reduce their findings to writing and deliver those to the teacher. So consideration, again, call us early. Here's how we process it. We're going to go through, was it corporal punishment or child abuse? Yes and yes. I think clearly the answer to both is yes. We're going to look at his history. I mean, this is not an automatic termination. You legally do not have to terminate, cancel, or non-renew this kind of teacher. We're going to look at the history. I mean, the past good acts do factor into the situation. The past bad acts factor into your decision on whether we're going to keep Matt around or not. Has there been any other misconduct this year? We'll focus on that. But we also look at even further back than that. And again, we look back to, is the board going to support you? What are the funky political issues that are flying around here? Who does Matt know? Who's Matt related to? Who does he go to church with? Who does he rent from? Who did he buy from? All of those kinds of things.
So one quick thing before Karen jumps into her, you can't fire for corporal punishment west of Kearney. This is why the fact of the matter is, before you start the cancellation process, we have to know what grounds we're going to allege at the hearing. So while with non-renewal, in every case, we review the documents before we'd ever agree that you have a legally sufficient case and issue the letter. But in particular for cancellation, the reason we ask, is there any other misconduct we'd want to bring up, is you have to list all the reasons in the initial letter. So we basically have to make an assessment, not just of whether it's legally sufficient, but how do we want to actually process the case so that it can go in that letter. So anyway.
So yeah, so there's the quote that I was jumping in to tell my story too early. Tim Thompson, who's a school attorney in North Platte, I took a corporal punishment case to hearing. I don't lose very many of these hearings, so the ones I lose, I'm really bitter and really fixate on. And so we took a corporal punishment case in Western Nebraska, and this teacher was mean to little kids, like third graders. Like if your hair was in your face, she'd pull your hair and roughly put a rubber band in it because she didn't like girls' hair in her face. And 100%, she would spank and slap hands, and she was mean. And I hated this teacher. It made me very angry. And the board in its deliberations said, we agree that she's mean to little kids, but our third grade teacher's really soft and our fifth grade teacher's really soft. So we think we need this mean teacher in the middle. Otherwise our kids will be too soft. That was literally what the board said in their deliberations. And I talked to board members afterwards and they confirmed it. And so Tim says you can't win a corporal punishment case west of Kearney. I don't know if that's exactly true, but look, we don't take these cases to make you look bad in front of your board. We want you to win. And so I think you should consider, are there board members who are going to say, yeah, Matt did the right thing. That damn kid should be spanked at home. Then he wouldn't have the problems at school that he has. Because that's difficult. And I don't know what to tell you, except that your board has that right to make that decision.
But it goes back to Karen's notion that at the beginning, when we say, is your board going to support you? That is probably the most important question. Yeah. You obviously have to have done it right, followed all the processes. But if you say no, I think 4 of the members of that board wondered why the heck Matt was even given a suspension or put on leave. Why would you bring that case?
There's a crappy case out of Iowa where a special ed kid was having a meltdown, and he like threw himself on the floor, and he's like kicking, and so he's basically swirling himself on the carpet. And the teacher, as he was swirling, he was getting closer and closer to the desk. So the teacher thought he was going to crack his head. So she grabbed his feet and dragged him several feet away from the desk, and gets rug burns on the back of this kid's, his back, because she's pulling him on the rug. And the parents sued for disability discrimination, saying that she had hurt the kid while he was having an issue based on his disability. In this case, that's something else that we would be asking about. The kid that's grabbing the door handle, does he have ADHD? Is he behavior disordered? Does he have a behavior plan about how he's supposed to be redirected? Because even if you can't fire Matt because you don't think your board will support you, this family could sue you for not firing Matt. Yes. If Matt has not been following the kid's behavior intervention plan. So these issues get real sticky real fast.
I was just going to say, one of the facts that they alleged in that Sergeant Bluff case was the school didn't fire Matt. Yeah. Right? I mean, that literally became one of the primary bases for them to show that the school was discriminating against the kid on the basis of disability. Why would you not fire a teacher that drags a kid so hard? And their doctor even came in and testified that I've never seen any sort of reaction by a teacher that led to these types of injuries. So they'll get people to say whatever it is they need to make that case.
Okay, so it's my turn to talk about our favorite employee, Bitmoji. If you know Sherry, you know that she loves her some Bitmojis. So I'm very entertained by these Sherry's Bitmojis. So this is the I don't give a flying fig veteran teacher who just doesn't really care. So you've inherited Sherry. She's a 37-year veteran. She's also the state championship softball coach, so she feels pretty entitled to be in the district. After 16-17, she quote unquote resigned from coaching. This makes me crazy. Teachers don't get to resign from coaching, just like they can't resign from teaching third grade, right? They're gonna do the duties they're assigned to do, but whatever, we let her resign. And she put her longtime assistant Jordan in to replace her because she hates the outgoing principal, so she wanted to show that she was the boss.
She pulls a Tom Osborne, is what she does.
I wouldn't challenge God like that. Sherry's still a teacher, but now that she's not coaching softball, she really doesn't care that much. She was all about the softball, so her performance in the classroom and in the clubhouse has steadily declined. All throughout last year, it's clear that she's already doing the math to see how fast she's going to be able to get her check from the retirement system. This year, she's clearly checked out. Her kids just do worksheets all day long, and they've got questions. She tells them to, look in the book. She doesn't give them much instruction. Like you have a big staff meeting at the beginning of the year, and you tell them, you've got a smart board, use it, or they've got one-on-one Chromebooks, use it. And from the back of the room in that in-service, Sherry says, I have an overhead projector. It works just fine. I don't need a computer or this snap face crap. So none of you have this, teacher. So you start to see that now she's polarizing other veterans, right? Look, if Sherry doesn't have to use technology, why am I using this?
When you're a second-year principal, so she's feeling like she can run all over you too.
Yeah. And so you walk up to the boss and start talking to the superintendent about the fact that you've got concerns. Problem is the superintendent hasn't been doing this all that long. And the superintendent's kind of a little bit leery and says, if you try to move her along, she'll just fight. So just make sure you've got your ducks in a row so that we don't look bad in front of the board. Based on what you've heard today at this webinar, you're like, you know what? I need to go and look at everything else she's got in the file. Here's what you find. In her evaluation last year, you said, you're very popular, but remember, you must challenge all students. Quick footnote. See how this was written in the third person? That is very typical. That is not what we like. I would prefer you to say, you are one of our most popular teachers, but you must remember to challenge. But what is written here on the slide is what we see a lot of the time.
And really what you're trying to say, that you're a first-year principal, right? And Sherry's been there for 30-some years. What you're saying is stop being the worksheet teacher.
Yeah.
But you haven't said stop being the worksheet teacher.
Yeah, exactly. She also cursed at umpires multiple times during softball games. She got ejected twice. Again, I will tell you, just isolating for a second the coaching side, we do have a professional practices complaint pending right now against a coach alleging that he cursed at the students. I called over to the department and said, hey, is it unprofessional for a coach to curse at the students? And the attorney that I was talking to on the phone said, oh yeah, you're effing right, it is. So telling your coaches not to cuss is a good thing. 4 years ago, before you were there, she yelled at the principal / activities director because they canceled the game and called him Charmin Soft in front of the team. That would make her coach of the year in Steve's book, but about 3 years ago, she's not keeping her grade book up. She doesn't like PowerSchool, and so there's a bunch of stuff in the file where she's been emailed or it's been documented that we have to tell her to update her grades.
She's got every red grade book going back to the first year. The ones with the red cover.
Yeah. But the teacher,
hypothetically,
but the parents don't like that. The parents, all these helicopter parents, they're in PowerSchool every day, and so they're freaking out that their kid's math grade is not updated. Your predecessor in his last semester did a memorandum to the file where he talked about a conversation he'd had with her, where he basically confirms that he has the same concerns that you have. She's got to stay engaged. She has to do more actual instruction. And she says, worksheets start with work. And if you're a parent and you want to know the grades, they can call me. Everybody knows my number. They don't need to look at this PowerSchool nonsense. That's stupid. But notice it's a memo to the file. It doesn't show that she's ever seen this memo or that that he actually conferred with her about the content.
Which is the value of a written reprimand versus a memo to the file if you're really thinking through it.
I hate me memo to the file. I want everything to be given to the teacher so that we can use it. So what do you do? Here's some of the stuff that we would do if you called. I would say, send me everything. And then the principal says, well, I'll send you my evaluations. No, you don't understand. I want everything. Going back to the time that Jesus was a little boy, I want it all. Because you can start to see things, right? What you're paying us to do is to assess whether we've got it, right? And so giving us just pieces and parts is not enough. Then 9 times out of 10, after we say send us the entire personnel file and you send us a bunch of stuff, we call back and say, no, send me everything. And so what I want, I kind of feel like I have the entire file. When you've included stuff like leave requests and their letters of recommendation, I don't need that, but I want everything that goes along with it. All the emails, all the evaluations, even the ones that were handwritten by, somebody that was there 20 years before you even were born.
And we're going to ask you to review all of Sherry's emails. Yep. Because somebody like this that will say that in the middle of a meeting, imagine what they'd say in an email.
There is potentially such wonderful stuff
Well,
in emails.
We're giving Karen
Um,
plenty of time here before we're done to talk about the Robinson case, because it is a perfect example of what a case looks like before the email search and what it looks like after the email search.
Well, we had not the Robinson case, a different case where we looked at the teacher's emails, like we hadn't gotten around to it till right before the hearing. And the teacher's Gmail, she had her email here, and you know how you can run folders down the side. So there's a folder for, like, you know, math class and whatever. And then there's a folder called bullshit. And in that folder are all the emails from her superintendent telling her stop being a bad teacher. And she's labeled them bullshit and put them in a folder labeled bullshit. Oh my God, that was the most
It was awesome.
fun. It was awesome. So yeah, look at everything. You just never know what you're gonna find when you kick that rock over. So after we've reviewed everything, here are the elements we're gonna consider to see if you have a legally sufficient case. First off, have we evaluated her pursuant to our policy? Now, let's say, what's she, a 20-year vet, 21-year vet? Let's say the principal 25 years ago dropped the ball and did not get 2 evaluations in when she was a probationary teacher. That does not mean she has super tenure, but we need to know that. We need to own that. And everything that you've done, we need to make sure has complied with the board's policy.
So real quickly, maybe you're going to hit on this, sorry, but there is no once each semester, right? That how you evaluate tenured staff members is done pursuant to policy. There's no statutory requirement other than to remediate them, but yes.
And one of the things that we see in policies is, I'm looking at a text that came in while I'm talking. So one of the things we see in policies is, I like it if the board says every certificated staff member must be evaluated once each year, but some of your policies don't do that. Some of your policies have like these weird, like evolving stage or improvement phase or whatever, so that basically a teacher only gets a formal evaluation once every 3 years, whatever. But you need to read your policy and see what that requirement is. And then make sure that you're not assuming that your policy says what your last school did. Oh, there it is. Some are once every year, some are once every 3 years, some have some kind of weird combination of the two. We would check with, when you send us your evaluation policies, we would check to make sure you're evaluating complied with it. But then I also would probably email the NDE lady that does your evaluations and have her send us over what's on file. And we would go back for all the years that have relevant evidence to make sure that it's been done according to Hoyle. The other thing that we look at, the other thing we ask for you to send us the entire file, is that teachers are required by statute to demonstrate professional growth every 6 years. And so I want to make sure that she's done that, because if she hasn't, we'll throw that into the mix and make that one of the reasons we're going to take action.
We had a quick question regarding the matter must be confidential until the hearing. What if you have a board member who likes to talk in public? Hypothetically, not that happens all the time.
So this is why we don't tell board members. We would not tell a board member Sherry's in the process of getting let go. Even after Sherry has requested a hearing, or if we're back on Mandy, if Mandy has requested a hearing, we don't tell the board that it's Mandy until after Mandy has requested a hearing, and then it becomes public.
So then the follow-up to that, can anything happen to that board member? If they've made it public, then they technically have violated the statute, which says we're required to keep it confidential until the hearing. But
We've not gotten a ruling from the court about what the consequence is. My fear is they're going to say you violated the teacher's due process. You cannot now renew, terminate, cancel that employment. That's the real risk.
I love you all. I just got a text about like an urgent thing, so I've got to step out, but Bobby's going to take over this section of the slides. So love you, and I'll be back in a second.
okay, so the difference, basically, let's say that you've gotten to the point where, all right, we've gone through it, we think there's a legally sufficient case. So now at what point, when you start to prepare for, okay, we could have a personnel case here, if I give notice of termination, how do we process that? So by and large, the process you're going to use for a termination, right? If you remember from the beginning, that's the only thing you can do other than cancellation to end a tenured teacher's contract. So we're considering giving notice of termination. It's the same as the cancellation process that Steve covered, with a few differences. Number one, whereas cancellation can be delivered anytime, right? Let's say that something bad happens on April 16th. You can no longer terminate Sherry's contract, but you could cancel it. So what we're talking about here is similar to the non-renewal process. If you're going to terminate the contract effective at the end of the current year, that has to be provided by April 15th. And for reasons that I've never really understood, the just cause standard for cancellation, right? You'll hear Karen talk about them as the 7 deadly sins, is actually different than the legal standard you need for just cause to terminate a teacher's contract. So cancellation and termination are slightly different, and here's really how they differ. You'll notice that most of it is the same, but the thing that we always put in the contract about other conduct which interferes substantially with the continued performance, technically that's not in the cancellation statute, but it is in the termination statute for just cause. So there are a few differences. Make sure that when you're when we're working through the case with you, obviously this is what we talk about. When we list the reasons in the notice letter, we have to make sure to talk about them just slightly differently. Because in most of these cases, you're gonna argue that some of this conduct interferes with her continued performance of her duties. So real quickly, I'll let you laugh at the cartoon. Okay, so we're going to talk now about the relevant cases. This is Karen's. I'm deciding if we should skip it or not. I'll let her add her gloss onto it if she wants. So this is a case where I sat second chair with Karen. This is several years ago, and this is in Bridgeport. And so Karen is prosecuting a case of the case of Patrick Robinson, who is represented by a private attorney, not an NSEA lawyer, that is very much, how would I put it, a frontier lawyer. He's got a
very aggressive and built better for the criminal system than an administrative unit.
Right. It felt like a criminal prosecution the entire time. So anyway, to set the stage, we're out there. We've done a lot of prep. Really good school board. Really good administrators. To start the hearing, Mr. Brenner stands up and objects to Karen prosecuting the case, saying that Karen is biased because she had exchanged emails with Patrick Robinson, who had actually emailed Karen to ask Karen if she'd represent him against the school. So Karen sends back the appropriate response from the legal ethics standpoint, saying, no, I represent the school. I'm sorry, I can't represent you. Please, don't contact me any further. Well, I'm sitting there, having not done all the preparation for the case, and watch him stand up and object. Basically, he says, Karen, you should have to go sit in the audience. You got another lawyer there that can do it. So I remember this case very vividly for that reason, if not other. But eventually, Tim Thompson, who's the hearing officer, says, no, Karen can prosecute the case, and away we go. So basically, here's what happened. During the 13-14 school year, they hired Mr. Robinson. And he had several incidents that popped up his first year. It became very clear to everybody that he was a bit of a different cat. That doesn't make him necessarily a bad staff member. But there was an incident that essentially happened on Veterans Day where he himself was a veteran. And so there was basically a dust up about whether he could park in the reserved parking spot for veterans that day. The administrator said, no, you need to move Mr. Robinson. That's intended for like the veterans that are going to come in as part of our celebration. We respect and appreciate and thank you for your service. But that's not the point of those parking spots. So there was, some dust up that related to that. Then there was this issue of he was leaving notes in a particular student's locker. And basically what they were is inside jokes, he called them. So it's that sort of, we're clearly not over the cliff. This isn't sexualized in any way, but it's strange enough that the administrators looked at that and thought, it's odd to have a first-year teacher putting notes, private notes in a student's locker, a high school student's locker. So they basically told him, stop doing that. He files a complaint with the administration saying they're targeting him. And eventually, in the second semester, they do look into that, resolve it, and say, okay, after investigating, talking to the students and everything, there wasn't actually anything inappropriate going on other than it looks a little bit suspicious, maybe a boundary violation. After that, because it significantly affects him, and to some extent understandably so, to basically have been accused of being a predator. And so that is repeatedly comes up in the documentation. I'm not a predator. Everybody's now targeting me. This false allegation has made me look different to everybody that I work with, and I'm just this first-year teacher trying to make it. So he starts retreating, refusing to meet, refusing to leave his office, and that stuff starts to intensify over the course of the year. Because of all of this, he files a complaint with the Bridgeport Education Association, with the Nebraska Department of Education, and he asked to meet with the school board to discuss the fact that everybody's been targeting him in February of his first year being a teacher. Want to take it?
I can. So he and his brother-in-law or somebody like that is an attorney, so I think he does have legal help. But he starts to submit these formal, very, very legalistic looking written complaints. Some of them he sends to the school, some of them he sends to the school's attorney. The school's attorney at that time tries to undertake an investigation and create some good paper for the district. But then there's a new sheriff in town in 2014. And the new superintendent, first off, everybody thinks that when they're the new administrator, they're going to take this crazy employee and make them better. I can't tell you how many times I've had them say, well, now that I'm involved, okay. And sure enough, the new administrator tried to give this person a fresh start, but Mr. Robinson just wasn't having it. So in August, they have a meeting of the union because Robinson has filed a complaint with the Equal Employment Opportunity Commission, saying that the union has failed to act to protect him. So the union meeting is not held at school, it's held in the city library. One of the people that's there is the attorney, Nick Welding, who's a good lawyer. And Nick does a great job. And the reason I know Nick did a great job is because I got to listen to the entire meeting because a teacher recorded the meeting. And you can hear her, we know who it is now, turn on the recorder. You can hear the fluffle, fluffle, fluffle as she puts it in her purse. You can hear her walking into the meeting, and then you can hear everything that everybody says. So Robinson has filed this NEOC complaint. Nick does exactly what we would do if we have a complaint filed. He stands up, he explains the process, and then he says, look, guys, you cannot retaliate against Mr. Robinson. You cannot treat him differently. You can't isolate him. You can't refuse to talk to him. You can't, say mean things about him. And the funny thing is, Robinson says that what Nick really did was tell the teachers exactly how to retaliate against him. Because he says, oh, everybody knows what the lawyer really meant was, here's a checklist of all the ways to retaliate. In this meeting, teachers are saying, look, Nick, we're scared of this guy. He's creepy. He is not normal. He's a weirdo. This guy had talked a lot about being a veteran. Did you talk about Veterans Day?
A little bit.
This guy had already pitched a fit because he didn't get special parking for Veterans Day. He's telling people all about all the stuff he did in Kabul and all these, like he's a sniper or whatever. I don't know that it's true, but the teachers are concerned that he's got these military skills. And so they start sharing with the union lawyer about what they're supposed to do. Nick does a great job and says, here's what I'm telling you, treat him the same, which is the right thing.
Be professional with him.
So this administrators, in the meantime, now we've got this war between the union and one of its members. We're just trying to, educate kids and keep everybody moving forward. So as the school year starts, they're trying to work with them. In the meantime, he's telling the principal and the superintendent that he won't come out of his office. He won't talk to any of them. They all are a lynch mob. They're all out to get him. We meet with him and tell him that he's not being effective. At one point, we give him his activities pass, to get him in free to all the school activities. He returns it, and then he sends this long diatribe email to the superintendent about how he would never come to any activity because Bridgeport sucks and the staff sucks and he knows his rights. And after he returns the activity pass and sends this diatribe, we decide, and by now I'm involved, we decide this is enough. He's going to go on paid administrative leave because this is just untenable. Now, this is a brand new superintendent, and he's come into a district that has a lot going on. So you can see this is kind of a weird feature of this case. We put him on administrative leave in September, but we didn't give him notice of cancellation until February. We needed time for this superintendent to get to know his board. We needed time for some other pieces to fall into place. We also needed time for the teachers to stop being so freaked out. But notice there is no procedural violation from taking your time. Once you get him out of the classroom and out of the building, you can let everybody kind of catch their breath and decide if you're ready to go or not. Now, the bad news is you're paying him not to work all this time, but the good news is being deliberate about when you're going to issue that notice means that once you issue the notice and it's go time, you're ready to go. I think administrators should take advantage of this more often. I don't think we should be in such a hurry to give people cancellation notice. If you need to have time to catch your breath and get your ducks in a row, but you don't think they're safe in the classroom, or you think they're just so toxic to your staff you don't want them there, there's absolutely nothing wrong with putting them on leave and letting them sit there. This guy was a curriculum director, so we didn't have to hire a sub necessarily to replace him, but I've got no problem with hiring a long-term sub or a replacement teacher while they're on administrative leave. That's gonna be way less money than going to a hearing before you're ready. So we hold a hearing. I think this hearing was, let's see, we went all night and then stopped and took a little nap and then came back the next morning. So I think we had like, what, 26 hours of testimony?
Yeah.
Something like that. It was a fun hearing. We had armed law enforcement there. The community was there. It was a good time.
Karen ends up having to call the county attorney to testify as a surprise witness about the sufficiency of the Open Meetings Act. It was crazy.
It was so much fun. It was a great hearing. The lawyer also put his own, he didn't trust the court reporter because he said that we'd hired a bad court reporter. So he recorded everything with his own recording devices, including, I suspect, recording our private conversations at council table.
He set up a camera on the far side of the room and pointed it right at Karen, which is awesome.
It was awesome. I wanted to give him all kinds of special hand gestures, but I did not. So the board does the right thing, cancels his contract. Patrick Robinson appeals to the Nebraska Supreme Court. And the Nebraska Supreme Court did a great job. First, one of the problems, oh my gosh, make a note of this, because those of you that haven't looked at your policies, this is an issue that I worry about. The Bridgeport policy said, notice of our meetings will be made in a manner that has been determined by the board and recorded in our minutes, which is exactly what the statute says. But notice that that policy never says how you're actually going to notice the meeting. It becomes circular. And so Bridgeport had that kind of a policy. It's really common all across the state. And so Robinson's attorney said that this was an illegal meeting because we never said how we were going to notice it. Now we had posted it in 3 places and put it in the paper. So that's why I had the county attorney testify, because he had personally seen the notice. So it showed that the public did get due and proper notice. But I don't like those policies that don't say how you're actually going to notice the meeting. But we won that in the Supreme Court. They said the meeting was proper. One other argument they made was that the Board of Education can't use a hearing officer. The statutes specifically say that, like, Lincoln and Omaha can make personnel decisions based only on an attorney having a hearing and then that attorney telling the board about it. We can't do that in a Class 2 or a Class 3 district. But we still can use an attorney to advise the board. That's what the Nebraska Supreme Court said. It was a stupid argument from the beginning. I was never worried about it, but it's nice to have it be in black and white. This is the thing I think is the best information out of the Robinson case for the average district. Robinson said, hey, I demanded a meeting in front of the board in February. The fact that you gave it to me means that you were biased. And the Supreme Court said a teacher cannot bias a board by giving a board information and then later on saying that you can't fire me because you know what I told you.
And I think we would argue that this rule would apply to Cody's father-in-law.
Yes.
In the case where he shows up and yells.
Yes. Now we did in this case have every board member sign what's called a voir dire affidavit, something that says, I promise I can make my decision based only on the hearing evidence. And more, I think we're going to start using those just because the court here said, look, they all signed the statement, if that's good enough for us. So that was actually the issue I was most concerned about in this case. I always thought this argument was stupid, but the lawyer said, when you renewed his contract at the end of the 13-14 year, all the bad stuff from 13-14, you can't use that in 14-15. Like every year is a fresh start. Bobby's dad says, even a skipping stone eventually stops, right? And so what the lawyer was arguing here is that if you keep skipping, we can never use the past skips against you. And that's not what the Supreme Court said. They said you can look at the entirety of their history.
Which is significant in this case in particular because, and we'll get to some of their quotes because I think it's important to think about as an evaluator. But it also is important for the case of this teacher that Karen's talking about because that stuff, yelling at the umpires, I mean, if you can show that began a pattern 4 years ago of caring less about her professionalism, that may make it admissible. So winning this argument was bigger than it seemed because in a lot of these cases, like this hypo, you're going to want to look at stuff from past years to show that.
I had a cancellation hearing last year where a teacher made an inappropriate comment like in October, and it was the first time in like 18 months he'd said something inappropriate. But going back a couple of 3 years, he had been reprimanded for inappropriate comments. 100%, you don't get a completely fresh slate every year. You don't get to drop the F-bomb on kids once a year. And as long as you didn't get fired that year, you get a fresh start. That's just not what the law says. So that, and I always believe that, but it's nice to have the Supreme Court say that.
Not a bad argument in that we're canceling the contract for this year, right? Your contract is a 1 year. It hasn't renewed for next year. Last year's is over. So but anyway, yeah.
I always thought it was a stupid argument, but yeah. And then I read this out loud in my car because the Supreme Court just hammers him and says he was incompetent, he neglected his duty, he was unprofessional, he was insubordinate. There is more than sufficient evidence to cancel his contract. Okay, so here's some just good language from the Bridgeport case. This quote is exactly what we were just talking about. The board can consider all relevant conduct when determining whether to cancel a contract. It doesn't just have to be the stuff that happened this year, and it doesn't just have to be the stuff that you were the principal for, right? It can go back to prior administrative teams.
And I would guess that's not going to be limited to cancellations. They'll apply that to non-renewals and terminations also.
So one of the things that they didn't raise that they should have is that Rule 10 says you must include all of their deficiencies. We've not yet had a lawyer raise that issue. I probably shouldn't have just said it out loud on something that's going to be recorded, but eventually, I think that the all language in Rule 10 conflicts with the Supreme Court's opinion here, which says if you heard him say something that you didn't put in a document, that doesn't make that inadmissible. The board should be able to consider that just because it wasn't included in the list of deficiencies.
I'm not worried about that. And this is especially true when the past conduct is intertwined with the conduct thereafter and deteriorating job performance. So this is why I'm not worried about that language in Rule 10, because it's all going to be part of one big ball. And whatever they did wrong this year, we're going to document, and then we'll pull in the other stuff and say that it's intertwined. That's at least my game plan moving forward. When it's necessary to think about the prior stuff, understanding and evaluating the reason for the cancellation now. That's another reason to be able to pull in old stuff. And again, I think that rest gets to a kind of argument that this is the whole story that you needed to hear. It makes sense to the Supreme Court, and we're going to be able to use all of that stuff.
All right, we're going to go back in time a little bit, going back 40 years. Shortly after the Tenure Act was adopted, they had a trio of cases that gave us some guidance that are still useful today. In Sanders, we had a 7-year PE teacher at South Sioux. The evaluations were always good or excellent until the 75-76 school year. And then we had a whole 2 categories that were marked needs improvement: classroom control and student participation. You'll notice here it says the board voted to consider termination. And as we went through that statute earlier, it does say the board or the superintendent or the superintendent's designee. It is very unusual to have a board vote to consider the termination of a teacher. That was probably a bad sign from the get-go. That essentially meant the administration maybe wasn't on board. And so lesson to learn there, especially for the attorneys. So at the hearing, we had the superintendent testify. The superintendent said, well, I never evaluated Sanders, but I did see that she wasn't present to supervise the drill team a couple of times, and that was one of her extra duty responsibilities. We had the assistant principal, and again, assistant principal didn't evaluate either, but sometimes I had to discipline her students because she wasn't doing it, so that happened maybe a few times. Then we had the principal, and the principal is actually the one who evaluated the teacher, and he had some I guess relatively minor complaints, nothing major, stuff that easily could have been remediated if the teacher had ever been told about the problem. But the important part here is the principal, the one who actually evaluated the teacher, recommended she had to come back. It's not that bad. I mean, these were minor complaints I had. Bring her on back. Board ignored that and fired her. Again, the board is the one that was driving this train. And so the Nebraska Supreme Court said, well, wait a minute. We got a teacher who didn't violate any rule, didn't violate any directive from anybody. No area of performance was rated as unacceptable. And we hammer on this one.
Yes.
We don't care what your evaluation instrument looks like. And this is why we hammer on it. Are you willing to check the box that says, no, they aren't good, they're terrible, they're horrible. Whatever that rating is, are you willing to check that box? This is why. I
want to jump in here. First off, if you've been doing this for a long time, I cannot recommend enough going back and refreshing yourself on these things. Every time I reread these old cases, like we talk about them, but we forget like how clear they are. And right here, this last bullet point that Steve has pulled up on the screen, we have now, again with Danielson and Marzano, there's like needs improvement, basic, proficient, and exemplary. And we have boards that have said in their policies that basic is not good enough. I hope that will carry us home. But in Sanders, they specifically said you had to mark unacceptable. And so if you have a 4-part rating scale and your board has said the first 2 aren't good enough, but one of them doesn't say unacceptable, I'm worried that some enterprising lawyer is going to get into Sanders and say, you have to check the lowest box.
In this case, Sanders was not performing below the standards required of other teachers. So again, we were comparing them to the other teachers. The next one we had, the very next year, we had Davis. Davis was a tenured teacher at Callaway. The administration in this case recommended termination, and the board terminated after a hearing.
And the true reason, if you read the case, that they terminated him is because he had really bad BO.
Yeah.
I believe that's a big part of it.
Actually, that was Hollingsworth, not Davis.
Sure.
Yep. But at the hearing, we had the superintendent, and again, in this case, the superintendent personally observed the teacher. Teacher lacked organization, lacked control of the classroom and students, and had poor planning skills. And the superintendent's recommendation was this guy should be terminated. Principal, again, personally observed the teacher, did evaluations. There's a lack of discipline, lack of organization, and said terminate. There was a whole slew of other witnesses. They were all in favor of Ms. Davis, saying you should bring her back. She's very good. Nebraska Supreme Court said this is not the Sanders case. Here, the expert witness charged with the duty of evaluating the performance of the teacher testified that she was not meeting standards. This is why when we go to a hearing, they'll bring out a lot of parents, a lot of former students, a lot of people say, oh, this teacher was the best thing since sliced bread, and but for her, I wouldn't have gone to Harvard and cured cancer and done all these things. It doesn't matter. They're not experts. You guys are the educational experts, and the court has said, we need to hear what the educational experts have to say, and they're going to give your opinion a great deal of weight. These other people may have been wonderful citizens, but they didn't have the qualifications to evaluate teachers. And so they're going to factor that in when they're considering a board's decision. Both administrators said the teacher neglected her duties. Expert opinions were sufficient as a matter of law. So clearly you guys as the experts, that's why we want to get your opinion. We establish you as experts, and then we get your opinions and the evidence based upon what that information is.
Now, in an actual hearing, I'll tell you the worst objection of my life I made in a hearing in Hemingford, where a bunch of parents had shown up and they were talking about how awesome the teacher was. We had it in spades with the principal, who had done a great job, and the superintendent, but the parents all were talking about how great the teacher was. And I stood up and said, objection, they are not experts, they are just parents. And the whole room was like, woo. So we will not probably say that out loud at a hearing, but that's why we don't really go after the parents hammer and tongs, because legally their opinions just don't matter.
Now we have
Hollingsworth,
a couple years later. Again, another tenured teacher. This one's from Alliance. He received good evaluations. Just didn't fit in. It was kind of odd from what you read in the opinion. He had a conflict with another coach, but that was later in his tenure there. The students harassed him a bit, and that essentially was, as we'll get down here. Really, it did come down, as Karen said, it's his BO and bad breath. And it turned out he had some problems with his teeth, had to have $1,500 worth of surgery back in 1981. And so that's what it was blamed on. But everybody complained about him. So the principal goes to him in January and says, it's time for you to go. I need you to resign. He refused to resign. After this resignation, everything increases. Basically, we had no evidence up to that date. Now, all of a sudden, it looked like a witch hunt. Everything, there was an increase in his discipline. They complained about the way he disciplined students. They did a student survey. And basically, the principal admitted, yeah, the kids probably knew what the purpose of that survey was when it was issued. And again, after that 131 date, and complaints about his personal hygiene. The Nebraska Supreme Court said, no, wait a minute, all of his evaluations were good. There was absolutely nothing in the record to reveal what prompted that January 31st request for a resignation. But it says from that point forward, witch hunt. That's what we had. We had a systemic and diligent search for evidence which would justify the decision that had already been reached. So for whatever reason they decided he had to go, they pretty much trumped up the charges. The court saw right through that, and they said, that's not going to fly here. And he was reinstated. So you have the lesson to learn here is do your homework, do your work up to that point in time. If they had truly evaluated him and mentioned the awkwardness and mentioned his difficulty in having relationships with students and relationships with parents, there would have been a history of that over the 7 years. That could have been used. But in this case, they just didn't do that, and they tried to railroad him out of town.
This is why you can't counsel them out until you've got the goods on them. Because if you have that counsel them out conversation and it fails, Everything you do after that conversation looks like you made it up.
Okay, so the Schultz case, this is a really good one. If you're a superintendent there and you want to give your evaluating principals some continuing ed, reading these cases would be a really good idea. Like Karen said, when you go back and read them, you take little nuggets out of them and you put yourself in the mind of an evaluator and you're like, wow, that would be important to know that that's how our Supreme Court thinks of these things. So this is an elementary teacher in Fremont that essentially had worked for the district for a little while, took a break, and then came back and had a, I don't care, 10, 12-year tenure then. And basically, everybody concluded that this was more or less, I would consider her an old school teacher. I don't know what old school meant in 1982, but
It's not that old.
but you had the superintendent testify that she basically did not meet the standards of competence. You had the elementary teacher and the principal, or a supervisor and the principal testified to the same thing. She was a poor communicator. She was too gruff. She gave too much homework. You had a bunch of parents that testified essentially that she was such a bad teacher, she was too tough on the kids that they developed anxiety, right? So this is the millennial parents, helicopter parents case before we had millennials and helicopter parents. But basically, this is all that happens at the hearing. It's made to be a competency case. It's to some extent a little bit like the last example that the hypo that we talked about with Sherry, where she's really hard on the teachers or on the students, and they bring the case saying she's not meeting the standards here of the district of competency because she's not effective. So they go all the way through. She ultimately ends up getting terminated. They appeal it to the Nebraska Supreme Court. And essentially they said testimony of the parents is insufficient, even though they brought in medical complaints to say that their kids had suffered from nerves. This is back to Karen's concept that the opinions of the parents with respect to her competency as a teacher simply are unsupported conclusions at best. They are not the professionals. So when you see the court talking about it in those terms, it makes sense then. You have to let parents testify, of course, but what they really want to know is when they view the facts, were the experts that evaluated the teacher in agreement that she was incompetent? And here, what you have is the court saying essentially she received all above average ratings during the time she taught, or that she taught. So we do not see, in fact, the court says we're at a loss to see how the school board and the court below us could have found any basis in the record to say that she was not competent, did not meet the standards of competency. In fact, the court concludes by saying, Schultz is an old-fashioned teacher. Perhaps such teachers did not win popularity contests, but neither can they be said to be incompetent. Teachers are not required to entertain their students, only to teach them. So in other words, this notion of we have a bunch of parent complaints and nobody likes this teacher isn't necessarily good enough. The last case we're going to talk about is Johansson. And if you are an evaluating administrator out there, I would read the Johansson case. We will post it. We'll make sure that Sherry posts it up there. We've got a copy of it that I used actually recently for a school or an education law class. And it goes through a ton of these things we've already talked about. This is a tenured special education teacher in North Platte. There's a whole bunch of bad stuff that it's alleged to have happened essentially while Johansson was a teacher. Tying the student up with an extension cord, referring to students as an idiot, physically and verbally assaulting other students, having kids in the class hide from this student that he excluded from the class, putting soap in the student's mouth, shaking students, and all sorts of bad stuff. And the board terminated essentially for unprofessional conduct. The Nebraska Supreme Court says, when we're evaluating this case, essentially we're going to defer not only to the expert opinions, but also to the decision of a school board. If we were at a court trial, not a school board hearing, and a judge couldn't say that their reasoning, their basis lacked any evidentiary support, that's the only time that a judge could take over and substitute his or her opinion for a jury, basically. That's the standard that we're going to review these cases when they come to this on appeal to the courts. Admission of hearsay evidence is not an error. This was a big part of it. And this is where we say, we talked about the rule earlier, that although hearsay is supposed to be given less weight at these hearings, it is admissible evidence for a board to hear. What will typically happen in a hearing is there will be the introduction of hearsay evidence. So you're a principal testifying. And what did little Johnny say to you? Little Johnny said that he wrapped up Timmy with an extension cord. Did you see it? No, right? So you'll get an objection there. That's hearsay. It can't come in. And we'll go through the whole song and dance, and the hearing officer will say, okay, Board of Education, I have to admonish you that you're supposed to give this a little weight, but it is admissible for you to consider. That's where this rule comes from. So this notion of, a kid writes a statement or a kid tells you something. We don't like to call students as witnesses, and part of the reason that we can get away with that is because what that student told you can be admitted at the hearing. And then finally, to determine whether a conduct is unbecoming, even though not in violation of any specific rule or conduct, we look to the opinions of educational professionals and school teachers. So other teachers are normally expected to be able to determine the type of conduct which constitutes unfitness to teach. This is important because going back to the Bridgeport case, the Robinson case that Karen talked about, he called a whole slug of teachers to testify on his behalf. And the way that we dealt with the teachers was to say, you're a teacher, you hold a certificate, correct? Yes. The Johansson case then renders that teacher able to give an expert opinion, not that it gets as much weight as, but they can give an expert opinion just like a superintendent or a principal on what constitutes professional, unprofessional, and all those things, which is why we say you should have teachers document in writing while they still have, you know, the spine to do it before 6 months before a hearing, what the conduct is that they believe to be unprofessional. And so those teachers at the Robinson hearing all testified that yes, this, that, sometimes they disagreed, but basically all of this stuff is unprofessional conduct. So any teacher that they want to call in support, the NSA wants to call in support, our cross-examination tactic is to say, okay, do you think this is unprofessional? You sort of box them in front of their boss, right? In front of the board and the administrators is saying, yes, it is, no, it isn't. So anything I'm missing from those? I went through those really quickly. Again, we'll post them. The facts are really important to read through, obviously, in these cases. And I think they're good reminders of a lot of this stuff.
The lesson from Schultz and Johansson is you have to have the starch to mark does not mean.
Exactly. The lesson from all 5 of
Yeah.
those cases is that really, yeah.
So circling back to Sherry, I believe this is probably a legally sufficient case. I'm not worried about getting reversed on appeal. This is a question of, do we have the political support? She's won state softball. She's been there forever. She probably is really deeply embedded in the community and has taught Vacation Bible School with board members or whatever. So you're going to have to ask yourself that. It would be awesome if we can get other staff members to testify or to at least get agreed to be listed as witnesses so that we can show some unanimity. But I would posit this other thing. Sometimes I have administrators say, you know, I don't want to come in and swing the hammer my first year. That's going to hurt my the climate in my building. The flip side is you only have so long to establish that you're the new sheriff in town and what used to be okay is no longer okay. And your board just hired you, so they're likely to support you because they want to give you the support they need. You need to get started.
And one of the things we're going to probably tell you in this case, if you call, is, so how much are you talking to the board about this new culture, right?
Yeah, that's right.
That's why I think in your principal's report, it's not wasted effort to talk about these new cool programs that you're implementing. You're not wasting their time. This starts to build some cachet with them so that when you come in and say all that stuff that I've been telling you about for 11 months that I've been working on, she cuts against that very, very clearly.
Yeah, and I would also start telling the board early on that all the culture changes you're making are not necessarily uniformly supported by veteran staff. And most of the time your board knows that is an issue and they probably can guess who it is. But so then you've kind of got them, without saying it's Sherry, you can say, you know, some of the long-term staff are not necessarily supportive. You get the board mentally down the road, and then when it is Sherry, they kind of have already gotten emotionally invested in making some changes, hopefully.
Yeah, we're going to skip, we have a few other issues just in case we needed to fill time, but I think you'd probably, unless you want to say anything on those.
I was going to say, I thought we'd go here, just and see if we have anybody text questions.
Okay.
That's what I was going to do.
Here, you want to go back to
Go back to what,
just the
this?
first slide with the numbers on it? I think hopefully everybody, if somebody's got one of our cell phones, but if you have any questions,
I'm going to
send
go
them our
back to
way.
that slide where we show. Like the current slide, here we go. Now I need to share the screen again. Okay, so here are our cell phone numbers if any of y'all have questions. It is 11:56, so if you don't have questions, we don't have to like hold you hostage for 4 more minutes.
I got one question. Do you have any?
Yeah.
What should the counseling out conversation sound like? Really good question. I mean, you've heard us sort of push back against it a little bit. Very effective administrators use it effectively, but that's because they know they've got the cachet in terms of relationships and documentation and everything. What I think it looks like is you've done an assessment of the legal sufficiency of the case. You've talked to the school lawyer about whether you could proceed, because the one thing you don't want to do, unless there's talk about maybe, I guess, an exception to that rule in a second. But I think the one thing you have to be able to do is walk in there and say with credibility, I think the board's going to support me because I intend to make a recommendation. Now, if you want to handle this a different way, if you're thinking it might be better professionally for you to resign, you sure can. I have been, because the union has been attending more of those meetings, I've started to tell schools I think that's a good thing if they bring our union rep with them, because what you can't necessarily do with as much credibility as their representative is tell them things like, yeah, no, she was serious when she said that if any school calls after they give you notice, they're not going to be able to talk to them because they have a personnel case that they can't discuss. They're very serious when they say that if you apply at another school, they may ask you if you've ever been given notice of termination or non-renewal or cancellation of your contract. So some of those things can be effective in terms of, in telling them how it's going to impact them if they request a hearing. But I always say don't start that, don't have that conversation unless until you know you've got the juice to go through with it, and that you, if you're the superintendent or if you're a principal, that your superintendent would support you actually doing it if you say it in that meeting and they don't want to resign or move on.
So just think about the hypotheticals that we've had. If you have that counseling out meeting with Cody or with Sherry and you say, look, I think maybe you should think about finding something else because I'm not sure you can stay here. And Cody says, screw you, my father-in-law owns half the county, and you don't follow through on that threat, Cody is going to run roughshod over you for the rest of his career. It is better for you to not articulate that threat if you can't carry it out than for you to say that you're going to do it and then not do it. So I think it sounds something like, you know what, Cody, I've looked over your evaluations for the last 3 years. It looks like you used to be effective in the classroom. I think you can do it. But if you look at the documents that I put in there recently, it shows your attitude is changing. It seems like you might not be happy here. So if you aren't happy here, I would really encourage you to find someplace else where you can be happy. And if you let me, I can help you find that. If you don't choose to find other opportunities, I think I'm not going to have a choice but to recommend that the superintendent terminate your contract. I've talked to her about it, and she is supportive of us going forward. I would rather not have that blemish on your record, but that's your choice, not mine. And then I wouldn't give them a ton of time to think about it. I think over the weekend is enough. If they offer to resign then and there, for God's sake, take it. Have them write it down right there. Do not say, in the name of all that's holy, don't say go home and talk to your wife about it, or go home and talk to your parents about it, because the family is going to kind of convince them to go forward. And sometimes the local association thinks a hearing will be fun, and they will encourage the teacher to go forward when they really shouldn't. So if the teacher starts getting cold feet and wants to resign, take it right then and there.
Which is, again, this conversation with Cody only works assuming you've laid all that other groundwork.
Yeah.
You've met with him about what the other staff members are saying, about what he mentions in the teacher's lounge and at the bar on Saturday night. I mean, all that stuff has to be in place or you're just talking into a brick wall.
The other thing we do with Sherry is we say, hey, Sherry, you've been here a long time and you've done great work. We have new expectations. So I have this 5-point improvement plan ready for you. It requires you to read 15 books and go to 2 workshops. I believe in you and I think you can do it. If, however, at this stage in your career, you don't want to do that, you are eligible for retirement, but those are your choices. Get better and do all this work, or ride off into the sunset and we'll give you a nice going away tea. But you don't say you're too old to do this, or you don't want to do this because you're going to retire anyway. You say, I believe that this will help you, or you can retire. So you put that choice out there on them. Don't say anything like old dogs, new tricks. Don't say anything that would let Sherry sue you for age discrimination.
Yeah, nothing discriminatory. I don't like threats. I like presenting options.
I do too.
Yes, exactly.
That's really what you're doing, is telling you. And as Karen said, no matter what the context is, you have to be willing to follow through on what it is you say you're going to do. It's not a threat. It's just, here are the consequences of your decision.
Yeah. And we always ask in preparation for those conversations, what do you think the teacher's going to say or do? And then that can kind of inform the strategy. So the short answer to the question, what should the counseling out conversation sound like? It should sound like exactly what would be most effective with that teacher based on what you've done. There are certain things that I think are brought up in most of them. And if, especially if you're somebody who's an administrator that builds good relationships, you can say with credibility that professionally, I think this is what this would mean for you. But yeah, I think we would recommend tailoring it to what that person's going to think.
Last thing I'll say, and then I see it's 12:01, we'll let you go. If you're talking about a letter of recommendation, which you don't want to say, I'll give you a good letter of recommendation now, but if you ask for a hearing, I'm gonna punish you. You want to say, at this point in time, I would be able to give you a truthful letter of recommendation that emphasizes your positive attributes. But after we move forward, the lawyer, I don't think will let me do that for you because we would have other considerations. So you're not gonna lie in one letter or the other one, but the first one, before, if they resign, you'll give them a letter that emphasizes their positive attributes, which could be as simple as she came to school most days and she was always wearing clothes. You know, I've written those letters. I don't ever want you to lie. Okay, it's 12:02. You guys have been great. We will send out a little survey when we send out the link to the recordings and stuff. I say this every time, but I really mean it. We're trying to make these good. I want them to be excellent because I think this is the future. So we crave your feedback. So please take the time to fill it out. And then feel free to share the recordings or rewatch the recordings and let us know if you find those helpful. Thank you all, and oops, I think we're going to discontinue.